second degree from Walmart in Otsego County. You're convicted, you face up to 1 year in jail. Do you understand the charge and the maximum possible penalty?
Yes, Your Honor.
Your rights include the right to an attorney. If you wanted one but could not afford one, I would appoint one for you, or you could proceed without an attorney. You have the right to a jury trial on this matter. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. Pardon me, if the prosecutor could not do that, the matter would be dismissed. At that trial, you have the right to remain silent. If you chose to remain silent, your silence could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or an attorney ask questions of witnesses against you. Do you understand your rights?
Yes, sir.
As to an attorney, do you plan to hire your own, seek a court-appointed attorney, or proceed?
Proceed without.
All right. Do you get your mail on Hatch Drive in Gaylord?
Yes, Your Honor.
You'll be notified as to the date of a pretrial when you and the prosecutor can have a conversation, a phone conversation, to see if you can work this out. You'll be notified as to the date of that as well as the phone number. Just give them a call at that time. Do you have any questions?
No, sir.
Your bond will also be amended to indicate you cannot go to Walmart's property until this case is resolved. All right. So you're all set. You're free to go. Thank you.
Michelle, could we make a copy of that pleading for Ms. Brown also? Well, he was there briefly and then he blinked off. There he is again. Good morning, sir. Are you John Reading?
Yes, sir, I am. How are you this morning?
We're ready to go. Set that energy drink aside. We'll pretend like we're in court and we'll get started. Donna Brown is here with me in the courtroom, and you're here by Zoom, which is acceptable for this first pretrial. Let me call the case. It's 251969GC. It's entitled Donna Marie Brown versus John Paul Reading. We've had some previous cases. We had at least one with these parties in this court. I think there have been some actions in some other courts here. And this is a new general civil case. Plaintiff claims substantial damages. She caps them at $25,000 to keep the matter in the district court. District court has jurisdiction over general civil matters up to $25,000. It's $25,000.01. It must be removed to the circuit court. So am I correct, Ms. Brown? You're capping your request for damages at $25,000.
Yes, sir.
There are multiple claims. I've got, this file is already this fat and we haven't even started yet. This morning, I received a pleading from the defendant entitled Defendant's Motion for Summary Judgment to Dismiss for Lack of Subject Matter Jurisdiction under 2.116C4 and 2.116C8. And I haven't had a chance to really review it, and I haven't had a chance to deal with it. And the defendant filed it, but the plaintiff just got a copy when I handed it to her about 2 seconds ago. So I'm not ready to address that matter, but this is a pretrial conference. The defendant is here from his address by Zoom. If we do have testimonial proceedings, he'll need to be here in person. The plaintiff has filed a bunch of stuff including subpoenas and discovery motions and that sort of thing, some of which may be a little bit premature. The general rule in district court civil matter is there's no absolute right to discovery. And subpoenas don't just get issued willy-nilly. They cause a lot of work at the other end. So, Ms. Brown, you filed this action. You capped it at $25,000. What are you asking me to do here?
Your Honor, I'm looking for relief in this case. There was a contract in good faith between Mr. Redding and I for the children's enrichment, and I have paid for it, and Mr. Redding has stopped paying his contractual obligation. I did just recently submit a motion in to add on exhibits. I tried to follow the process because of the cutoff point, but this information was obtained through some of the other subpoena records in one of my other cases with Mr. Redding, where it does show that Mr. Redding was upholding the contract.
Now, you're talking about this contract. Is that in here?
Yes, Your Honor. Exhibit 1. This was outside of our friend of the court agreements. This is solely in good faith to pay for the lessons and enrichment for our daughter.
And one of the issues is whether this is jumping jurisdiction from the friend of the court to a general civil case. This happens in domestic relations cases. People are unhappy with a ruling in domestic relations. They file a small claims case, or they file a general civil case when the actual jurisdiction lies with the family court. So I can't tell.
This is for extra activities that were quite expensive. It was never part of any of our, it was never even requested in front of the court because it was.
But the argument is it should have been, that it should have been part of the front of the court action. It had to do with custody of the children, support of the children, enrichment of the children, and it should have been part of an order. I don't know that that's true, but that's the argument. There's so much stuff in here. I'm looking for the actual exhibit.
Mr. Redding was paying on this in Exhibit 8 that we can see outside of any friend of the court. He was making payments directly to me within this contract.
This contract, Your Honor, that's not a contract, it's Exhibit 1. It's just a note. And it's an explanation that she asked me to write to front of the court. I even write in there, I live in separate units of the house. So I'm not sure why she believes it's contract, but.
Well, I'm trying to even find it. She filed a pleading why this matter belongs in district court, not friend of the court. This is it. To whom it may concern, I verify that I am responsible for Kaylee Redding's dance and horse lessons per our custody arrangements. I pay Donna Brown the cash reimbursement for these activities, also assist with transportation mileage, or payment of out-of-pocket expenses associated with John Reading's medical expenses per the custody agreement. Donna is able to pay me bills out of this money. Not sure what that means. We live in separate units of the house and are separated through the courts, taxes, child support in place. Signed, John Paul Reading. This document doesn't have a date on it. So she's suing on contract exhibit 1.
I'm stating, Your Honor, this is a note that she asked me to write to the state because she was on state benefits and she didn't want to be disqualified. Hence the extra explanations in there. This is not a contract.
Defendant contends it is not a contract. But a note to the state.
Your Honor, if we could see Exhibit 8, it can show that Mr. Redding has been paying on this contract, and what he said is not true.
All right, he may have been paying it on a note. Well, so the first question is, it is a contract. Contract has offer, acceptance, an agreement that's only signed by one party. So there's a fundamental question about whether this is even there's several issues. One, should this all be under front of the court? Two, is this a contract? It's a note to whom it may concern. It's only signed by one party.
This is a good faith, Your Honor, agreement between us with a promise, and I acted based off of this promise and put the money out for our child's activities. And if you could hear this case, Your Honor.
And I will say she knows this belongs with front of the court with anything she's requesting. That's why she even tried to get in front of that before. But in the motion that I filed for judgment to dismiss, I kind of basically put that it lacks proper subject matter. It lacks material terms such as duration, price, payments, lacks clarity and specificity. I mean, it doesn't even have her signature. It's not even a contract. This is literally for her to get state benefits. And she's trying to use it later. She's literally trying to harass me and my wife. The last judgment she got, she sued us me over something that had a $0 balance by the time insurance hit it. She didn't want to provide insurance. So she's been using the child support reasoning case to get subpoenas to get my wife and my bank records.
Your Honor, I object.
All
Well,
right,
she submitted
let
all
me
there.
finish.
It's all there. She submitted literally everything that has nothing to do with anything, just to harass myself and my wife.
I object.
Okay. Well, he disagrees with you. You have a theory of your claim and he has a different theory. He objects to your claim and you object to his pleading. Right now, he's filed very late in the game a motion to dismiss under summary disposition. If he prevails in that matter, the case is over. If he doesn't prevail, then we can go further ahead. But I can't deal with this because you just got notice 1 minute ago. I don't expect you to come in on the fly and answer his motion for summary disposition. So I'm going to adjourn this for 21 days to give you an opportunity to respond to his motion for summary disposition. And then the second, if we get past summary disposition, there's a fundamental question about whether this is even a contract upon which you can sue. I'm not signing any subpoenas until we get further in this matter. Subpoenas are intrusive. They cause a bunch of work at the other end. They can be a form of harassment. Subpoena this, subpoena that.
Your Honor, the one subpoena was for me against my own employer because of the job loss caused by Mr. Redding and his wife. I know that they had falsely said some things last time in court about her.
Well, I dealt with some of this at the
But
earlier
this was
hearing.
evidence. That's what I was trying to obtain, actual evidence, not making false accusations as they have. Your Honor, Mr. Redding is very behind in child support, over 14,000, and the subpoenas the other subpoena is used to show that he has the means and capacity to pay, but he's not been honest to the courts. And I'm asking
That's not this case.
Correct.
You can't use a subpoena in this case to prove that he's not paying your child support.
No, this was to show that he had means and capacity to pay.
It's
this.
still not this case. It doesn't matter whether he has means and capacity to pay it. That starts if you get a judgment and then you attempt to collect on it.
Yes, Your Honor.
But right now, he filed this last second motion, which isn't fair to you to have to respond to it.
Okay.
So let's continue this.
To clarify, Your Honor, that's only like 5 or 6 months of child support. I mean, I know this is being live streamed, so
Say that again. I didn't understand you.
this is only about 5 or 6 months of child support, and I've still been making like very low $150, $200 a month payments towards her. It's not like I've not been paying child support for years. It's just for jobs where you're paying almost $2,000 a month in child support. It takes a little bit of time, panel interviews.
Yes, this is a child support case that is
Yes, sir.
lapped over into general civil. And that happens, as I said, from time to time. Let's see if we can find a place to put.
If you could, look at Exhibit 8, though, you'll see that he was paying on this separately in this agreement, so.
And I don't,
Yeah.
I think that probably is accurate.
Well, if I'm paying on something when we're all living together in the same household, I mean, that's a different
Well,
story.
one
than-
problem is that this thing doesn't have a date on it. I don't know if it's pre-order or post-order or,
Our child support orders were done back in 2015 and 2020. This signature was in 2023 by Mr. Redding. Additionally, when they move out of the house, this was a contract in good faith between us that it was not brought up to front of the court for any matters because Mr. Redding was paying on these things prior. And
it should have been. You're backdooring the front of the court by some sort of document that you call a contract. The front of the court has jurisdiction over child support and these sorts of issues. And you're claiming that outside the knowledge and belief of the front of the court, that he agreed to this contract. We'll have to figure that out.
Yes, sir.
Today is
She
January
submitted
26th.
this. She submitted all this to the front of the court, and they thought it was unreasonable that I pay $20,000 a year for a child to have a horse and do extravagant activities. If I choose to pay that when I'm living in the house, it has
That's
nothing to do with
correct.
anything here.
Your Honor, this has never gone to the front of the court because Mr. Redding was just paying on it, and that's why I made the decision to keep our child in an activity that was really helping her.
Okay.
All right, finding a place to put this is a little problematic. 21 days would get us into February 16th as a government holiday for President's Day, I believe. I'm gone Monday the 23rd.
Your Honor,
Yes,
if we could, since Mr. Redding and I have multiple things going on, the only way for me to collect is when we sell the house. Mr. Redding has not been paying on the house, and so I'm trying to partition that and push that through with Judge Pattison.
and
So
Judge
any-
Pattison has that case,
Correct. If
yes.
any judgments were to come from this, that would probably be my only window to collect from Mr. Redding. So if the soonest date possible, to try to push this along so that it could go in combination with our other cases, Your Honor.
All right. Well, I can rule on it right now, but you just got it. So I'm adjourning this for your benefit. So
Okay.
I'm trying to find a time to put this.
Is Zoom hearing
But we
something?
missed two Mondays in February.
Your Honor, Zoom hearings for the rest of this possibility, as I live in Texas.
Yes, this next hearing will also be by Zoom. I have to set it as soon as I can, but there's already stuff set. The 16th of March is not within 21 days. 16th of February, excuse me, that's a Monday, but we're closed that day. So the next possible day would be the 23rd, and I won't be here that day. So that takes us to March 2nd. Which is crammed full. So I'm going to continue this to March 9th. (2026) at 9:20. You're welcome to come in live or by Zoom. Block 9:20 to 10:30. We'll have more than an hour if we need it. You've got a number of things that you filed, motions, and some of these are not controversial. For example, leave to file supplemental exhibit lists. I won't have a problem if we get that far to allow you to file additional exhibits and witnesses. But the motion that he filed is dispositive. If he prevails, the case is over. And you haven't had a chance to respond to it. So you have 21 days from today to file a response to his motion for summary disposition. You don't have to file a response, but you have a right to. Unfortunately, 21 days would get us to March or February 23rd, which would be a good day, except I'm not here. So the next available space is March 9th at 9:15. He claims lack of subject matter jurisdiction, promissory estoppel, alleges that all child expense disputes should be made with the friend of the court, not the district court, and some other things. So we're on hold pending ruling on those motions. So that's really all we can accomplish. If you have any additional motions you wish to file, notice them out for that same date, March 9th. All right, that's, I guess, all we can accomplish at this point. I've reserved on all the motions that the plaintiff has filed. As I indicated, some of them are not very controversial. Should be easy if we get that far to rule on. But the defendant's motion for summary disposition cannot be heard this morning because the defendant hasn't had a chance to respond. Plaintiff hasn't had a chance to respond. So the entire matter is continued to March 9th at 9:20 a.m. We'll rule further on it. Are there, the partition matter is still pending in front of Judge Patterson, is that correct?
So initially I had put that in a petition back in 2024. It went through. Mr. Redding had it dismissed based off of our rights to survivorship. During our personal protection order hearing that I was able to get against Mr. Redding, Judge Patterson told us that it would be best if we changed the deed so then we could repartition. So we agreed to change the deed to remove the rights to survivorship so that I could put it back to petition to get Mr. Redding to sell. our attorneys were working on that together, and just on Friday, at the very end of the day, now Mr. Redding has filed something, even though our attorneys were working together to try to move this forward. So I really don't know. what the
I do
status is.
believe at some point that property is gonna have to be
It has to be
sold
sold. Yes, Your Honor, I've been trying to do
for
that.
everybody's interest. Right now, it's just in
Absolutely.
limbo.
Mr.
but-
Redding's not paying on it, and it's really a
Well,
financial burden to me.
I
All right, well, I'm
filed
not in
that.
that case. I know Judge Pattison would like to get that
Right.
case over the finish line.
Yes, Your Honor.
Well, in her last request, she wanted me to pay for her and her new husband to live in the house that I co-own, and that's the reason why I didn't. I got part of why I got it thrown out last time, and then she said she was going to file and then didn't.
All right, I'm not getting dragged into that
Sure.
tar ball. I'm gonna deal with this. At any rate, the whole thing is adjourned to March 9th, 2026 at 9:20 a.m. You have 21 days to file a response to his motion for summary disposition. And if you have any additional motions you wish to file, you can notice them out for March 9th at 9:30 a.m. I'm not going to rule on any of your other matters until that time. I'm not going to sign any subpoenas or anything further until the pretrial and hearing on motion for summary disposition. All right, Mr. Reading, anything further?
That's all, Your Honor.
All right, Ms. Brown, thank you. I know it was hard to get out today. School's off.
I know Corey on behalf of Mr. Serranis, who was at the podium in the court.
All right, it's the time and date set for arraignment. Counsel as to arraignment.
We'll stand mute and waive the formal reading, Your Honor.
All right, I'll enter a not guilty plea on your client's behalf.
Do you want me to address
Yes.
this, Your Honor, or address the pretrial?
I'm sorry, say that again, counsel.
Do you want me to address the bond, or did you want me to address?
Yeah. I mean, I see it doesn't appear that he has prior criminal history. Is that accurate?
He has none, Your Honor, and he's 31 years old, and he is employed. I would just request a personal bond on his behalf.
All right, I signed the order for fingerprints. Were you arrested, sir?
No.
All right, you'll have to go downstairs, get a copy of the order for fingerprints, and then you have to take it next door to the police department. This is a printable offense, so you'll need to go get it printed. All right, it's a misdemeanor punishable by up to a year. That's the statutory maximum. I don't see any prior criminal history. It is an assaultive crime. But based on your appearance here today, I don't believe you're a flight risk. You have retained counsel. And I don't see any violent history or any history at all. How old are you?
31.
All right, I'm gonna give you a personal bond. You have a $5,000 personal bond. These are the conditions of your bond. Sir, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Sir, you were to have no contact with Sapphire Brandon. I don't know what your relationship is with the complainant in this case, but I want to be very clear to you.
I didn't get that. Could you?
I'm so sorry. I said, sir. I'm going to explain to you what that means. You can't call her. You can't write her. You can't email her. You can't go to where she lives, works, or goes to school. You can have no contact of any kind. And you can't have a third party contact her on your behalf. That means your grandma, cousin, friend cannot contact her on your behalf. The only one who could potentially contact her on your behalf is your attorney. Do you understand that?
Yes, Your Honor, I understand.
All right. If you see her at a grocery store or in public, you're to turn around and leave immediately. If she contacts you, do not reply. Tell your attorney. Okay? This is an order of the court. If it needs to be modified in the future, it'll be modified in a hearing where both parties are present. You understand?
Yes, I understand.
All right. Did this incident, is it alleged to have occurred at her home or residence? I don't know. Counsel, do you know?
It is at a home, Your Honor.
Is 6041 Troy, who lives there? Is that just a friend's house or is this her house?
It's a friend's house.
Okay. If you go to a friend's house and you see her there, you turn around and leave. You don't say hi, you don't wave, you don't give her the finger, you turn around and walk away. Got it? Right, well, I'm not gonna say you can't return to that address. I don't know who resides there, but you've indicated it's not her. Cannot possess or have access to firearms or other dangerous weapons. Okay, so if there are any firearms in your home or dangerous weapons in your home, they need to be removed by a responsible adult in accordance with the law while this case is pending. You cannot consume alcohol or illegal drugs. You may be subject to drug and alcohol testing on demand. All right, and you have to be fingerprinted within 48 hours, okay? And like I said, Mr. Serranis, I'm gonna send the file down right now. And you will, if you go to the window and tell them you need a copy of the order, just give them a few minutes and they'll be able to get that for you, okay? Okay, and we will set a pretrial with, I see the complaining witness is present today. Complaining witness to appear. And counsel, do you have discovery on this case?
I have paper discovery, Your Honor, but when I spoke to the prosecuting attorney, she said there's possibly more and maybe some digital. So that is why we're doing this or adjournment to set for another pretrial.
All right, so we'll adjourn for discovery. And I see Ms. Grandmont's present as well, and both of you will receive notice of the hearing date, the next pretrial date, okay?
Thank you, Judge.
All right, and you can appear on Zoom. Everyone can appear via Zoom. All right, we're all set. And I see there's a date selected of February 9th.
Correct.
All right, we'll do it at 9 a.m. We're all set. Thank you.
Thank you, Ron.
All right, Albert Locke. Mr. Locke, you want to come on up? Wait, do I need Aaron up here for this?
No, it's just.
Okay, all right, this is 252379SD, the People versus Albert Locke.
Morning, Your Honor, Jeffrey Fant on behalf of Mr. Locke, day's time and date set for bond hearing for treatment court. We've gone through the bond conditions. Mr. Locke understands those. He understands he's going back down to see Ms. Wagaman before he leaves the building today. And I'm ready to proceed.
This is the second offense?
Got
How many offenses?
Several in the air. He's got 3 other courts he dealt with.
Yes. I'm sorry.
checked on it multiple times.
You're talking about this February 6th of a year ago?
Yeah, it's my understanding that it's still coming according to the people that I've checked in with. I just don't know why it's taking so long.
Where's the problem? Because this is abnormal, and there he is sitting around languishing. He's in the twilight zone. We got to move forward one way or the other. I mean, this thing was filed in May, and we still don't have.
I believe we're waiting on the labs for the drugs. I'm not,
Can you find out for sure? It's kind of important because if there's a delay, I'd like to know from the lab why. Because this is too long.
okay. I can speak to the lab. I know they have
They
it.
got a lot.
Yeah.
But motions to revoke, we're in the twilight zone. Those are important.
Turnover over at the lab too, Jeff, so trying to meet people.
How long have you been in custody?
Judge, if possible, while we're trying to wait to get the labs back, is it possible to set a bond for Mr.
How am I going to do that with what's is alleged here?
I'm sorry?
How am I going to do that with what?
Well, as a new case is it's been over 90 days and they haven't indicted, so they're not ready on those. And then on the latter part, this is if my memory concern is.
See, this is what happens.
This is a deferred.
They're going to ask, and the court's got to consider whether he should be now released. And we know what is happening. He's
got a job waiting for him, Judge. He will be in attendance.
He's alleged to be using synthetic marijuana. That's straight from hell. We all know that. Methamphetamines. Failing to provide verification of completing anger management that he was supposed to. Not doing community service. You mean this goes on? There is something I am curious about. Allegations 2 and 3 allege the exact same things. How can that be? What's
Your Honor, I believe that it's.
what's the distinction between those two? They're both, he admitted to using illegal drugs, synthetic marijuana to the police, and then illegally possessed synthetic marijuana on February 6th. Y'all carved out 2 allegations. What's the difference between?
I believe it's because of the use and the possession, Your Honor.
But
Condition 10 of this probation was do not use or possess. And according to this, he used and possessed.
It's alleging word for word, almost the same thing. I was just trying to figure out what you're carving out of those. In both of those state, he possessed synthetic used and then possessed on the same day in violation of the same condition of action. Here's the issue is, do you have in I mean, we're waiting on the drugs, but also there's an allegation he admitted to the police that to the Port Arthur police that he was using illegally synthetic marijuana. Let's just go on that.
Well, Judge,
What?
I'm going to have to object to going on that one because that would be part of any discovery on a new case. The state has not provided me any sort of anything to indicate that there was in fact a valid admission for this. This is simply someone pleading that he said he admitted to it. And I don't know that anyone in this courtroom can verify or testify to the fact that he said anything.
Well, can we?
That would be part of the new case. We don't have the new
2
case.
weeks. I'm gonna set this for a hearing on 2 weeks. Okay. And getting whatever discovery we need. And if we can't get the results, we'll go on what we can. because this is language too long.
Can we have a bond in the middle?
No.
Judge?
No, sir. Willie Coward.
Morning, Your Honor.
What is this one? We had, I guess, a hearing. 18-30013 is called your Willie Coward.
Yes.
All right. And the state and the defense are both here. There was a motion to revoke probation that had been filed back in 23. The defendant pleaded true in June of 25 to violations which were not substantive, but were failing to report properly to the probation office. So we continued him on probation. Here's a review. And from probation, how are we doing?
Your Honor, after the last court appearance, you had advised Mr. Coward to, if at all possible, to pay the restitution in full. And Mr. Coward did do
How much
that.
is that?
He
how much?
paid $3,569.12, which finished paying the restitution in full. The case
Happy
was,
as a lark.
Yes.
the case was originally set for May, and so I sent a memo to you advising that the restitution had been paid. He is continuing to report monthly to Ms. Young. He does reside in Vidor with his brother and sister-in-law. At that time of the last court date, you had advised that you would be willing to consider a lesser restrictive community supervision.
What else do we need to accomplish on probation?
Mr. Coward,
Because he's on, just not to interrupt you, but just for the record, he's been on probation now for over 6 years.
Mhm.
And if they do well, of course, we can shorten probation. And that's my question. Is he worthy at this time?
the majority of Mr. Coward's time on probation, he has been incarcerated within TDCJ. Mr. Coward,
Did he successfully complete that incarceration without
yes, sir.
parole revocation or anything?
He was paroled and that was revoked.
Okay, while he was on this,
Yes, sir.
okay. But he has been paid that price that was assessed in
Yes,
that particular case. On this one, what other conditions is the probation office is the probation office
The only
stating
concern-
needs to be accomplished?
The only concern that we have is Mr. Cowart does have some medical conditions. As of January the 6th, he did submit a drug test that was positive for his prescriptions as well as methadone. That's the only issue that I see at this point in time. We are prepared to, if you allow him to go on to an inactive probation, we can, we have an order of allowing that with some additional conditions such as reporting for random drug testing when requested, even though he is on inactive probation.
The drugs that he's testing positive for, those were not the prescribed drugs?
Not
This-
methadone, Your Honor.
Yeah. What happened there?
Well, so, I went to work with my sister and, didn't have my medicine. And, you get real sick on the medicine, and if you don't take it, and methadone, but the only thing that gives you any relief.
So you self-medicated?
Yes, sir.
Your Honor, that was the same story.
That's not the way to do it on probation.
That was the same story that he offered me in September of 2025 when he tested positive for methadone as well. That was addressed at that time, and we completed a substance abuse evaluation that recommended special needs safe P. But because of Mr. Cowart, he's a registered sex offender, he's ineligible for safe P placement.
All right. Shame on you the first time. Shame on me the second time.
Yes.
If I just say, we went over this and you know that You touch the stove and it burns. Why would you embrace the stove now?
Your Honor, because I thought we were talking about the first time, but I didn't know the second time. I was unaware that I tested positive the second time.
Well, you tested positive, but you would be the best person to know whether you
Yes.
used improperly or not. But the tests, we're going to rely on the tests unless somebody can prove that they were not administered in a correct fashion. The tests are scientific.
So I've read that the Jackson rule, they give false positives on something.
We're going to rely on the tests
Yes,
by the preponderance of the evidence or greater.
yes.
What are you suggesting, Ms. Stan?
Your Honor, I would offer the court two options. If you wish to dismiss the motion and continue him on probation, under a direct supervision, I would ask that you consider allowing him to report and ordering him to report directly to Jefferson County because of the fact he does reside in Orange County. We would even be willing to reduce his supervision fees half to $30, or you can place him on inactive. And if you'd like to review the inactive order that we prepared, if that would be substantial.
What do you think is in the best interest of success in this case? You're closer to him. I mean, those are, to me, that's 6 of one, half a dozen of another. I don't know how to weigh those, and I trust you.
Your Honor, Mr. Short did come through with what you asked him to do, with the exception of the recent methadone positive. He reports as he's directed, even though he's tardy at times, but Ms. Lakin Young is now supervising him and she's working with him. He would be transferred to a different officer with a direct report here. I would say that having him report to Orange County would be a hindrance on him financially as well as transportation. And that would be, I think, a path for unsuccessful probation.
Okay. If we continued him here, what conditions would you add, if any?
I wouldn't add any additional conditions, Your Honor. At this time.
I'm just concerned about that in the methadone.
Yes, sir.
Positive.
That's the concern, because of the fact that I specifically addressed it with him on the first one.
Okay, before I do something, go ahead, Mr. Turk.
Judge, the goalpost keeps changing on this one for us.
The goalpost changed because of him.
No, sir, not on this.
It was the methadone positive that's changed.
I understand, Judge, but just a couple of days ago, I got the recommendation from the probation office that they were going to recommend inactive. Now it's going to, hey, they're coming back and say, these are the test positives. Nowhere in this email, nowhere in these conversations where he's put in there. Couple with the fact that.
Guess what? They're allowed to change their thoughts.
I understand that.
Okay.
I understand that.
They're not making contracts. He made the contracts. He made the contract with me that we violated. So don't blame them.
I'm not blaming them. I'm just.
Yeah, but don't criticize them under these circumstances, please. Just what's in his best interest so he can be a successful person and be productive in life and be independent.
I think at this point, Judge, he's complied with most everything that everyone's asked of him.
Most everything. It's not almost there. Doesn't get you the participation trophy. I want the winning trophy for all this. Okay. What else do you want? Go ahead.
I had come into the impression that this was going to be recommended inactive probation.
Sorry about the frustration, but I'm not going to criticize these people. They produce a result that is unheard of in probations, and that's 93% success rate, which we're all proud of, and we want him to bring the bar up to 94 with his success. So they're not going to get criticized on my watch. They're working hard, and they don't mistreat people. We try to even drag them across the goal line if we have to, if that's what is necessary. But I want him to be independent, to make his own right choices independently. Here's what I'm gonna say. Okay. We're gonna, I like your idea. And what we're gonna do is we're gonna continue your probation and we're gonna do it that is cost effective for you. I want to review in 3 months for the termination of probation or not.
Yes.
Okay?
Yes.
And you do well, all things considered. And probation says you're doing fine, then that's what I intend to do.
Yes.
So, but let's get
Yes.
another 3 months. Also, do whatever it takes so that it's cost effective for him. So it's less costly and he doesn't have to make those drives.
Yes, sir. I have an order.
Oh, sorry, excuse me.
Sorry.
Supervisory fees are going to be reduced $30 per month. And you're ordered to report to the probation officer in Jefferson County. We will review in 90 days or less. If you feel like we don't need to wait 90 days, let's get him free.
Your
I
Honor,
think you're doing good.
Thank you, sir.
But once again,
Yes.
we want you to be on this 93% success rate, not the 7%,
Yes.
because I know, I believe you're able to, and that's, some people are hopeless sometimes. You just know it's frustrating that they're not going to make it.
Yes.
You are the ones. Just make the right choices. You know what they are. That 3 looks like a 5. Here is something. Bring it back. Probation. Review and let's get a resetting for 3 months, please.
thank you, Your Honor.
Thank you.
Your Honor. Judge.
Yeah.
Peggy said to tell you that she's working on the staff.
Hold on.
Thank you.
Yes, ma'am.
Yes, they're good. They're supposed to be bringing the restitution payment as we speak.
On which one?
Oh, Tremba. If you only, if you need to, but otherwise, no. Hey.
Good morning, you're Trinity Bell, and Miss Bell, were you able to get a lawyer hired? Did you talk? Who'd you talk to?
I talked to William Marcus and Wilkerson, Thomas, Jade, Burbank, and Redmond Jackson.
Okay, and so where are you on being able to afford one? Do you think you're gonna be able to get an attorney? Are you working? Okay, why aren't you working?
I was pregnant last year and I had.
Okay, so I'm gonna have you fill out some paperwork this morning. Thank you for doing what I asked you to do. You need to fill out this paperwork accurately and completely. Don't just leave it blank. You're gonna swear under oath that it's all true and correct, and I'll take a look at it in a few minutes. If you step in front of the clerk, she'll give you that paperwork. Joan Kraus. Joan Kraus. Have y'all heard from? Okay. All right, I have documentation from her bondsman, that she is currently in a hospital, so I'm going to reset her case for, let's do at least 3 weeks or 4 weeks or so. Carisha Mays. Good morning. Are you Carisha Mays? And Miss Mays, were you able to get a lawyer?
I spoke to Ms. Owens, that was Friday. She gave me some prices.
Okay.
but I'm not gonna be able to afford it.
Did you talk to any others?
No, I'm looking up some, but like I said, I won't be able to afford them. I'm having.
How do you know if you can afford them? And so here's the thing. Remember what I said when you were here before, right? Talk to them. They all charge different amounts, have different payment plans. Bring me the names of who you've talked to. I say the same thing to everybody. So I know I said it to you. And what did I say that could happen if you didn't do what I told you to do? Right. So you don't want to go to jail just because you don't do what I asked you to do, right? It's easy. Just talk to 3 lawyers. Then if you can't afford them, there's options, but you have to follow the rules first. It's just that simple. If you can't follow the rules, you're going to end up in jail. Okay. So I'm going to reset your case 2 weeks. You have 2 weeks now to talk to 3 attorneys or get one hired. If you don't do that, then your bond will be raised for not following that court order. Yes, ma'am.
I'm going through a transition right now. I'm not able to work because I just got my kid, the case with home.
Just do what I'm asking you to do, and then we'll talk about your options when you come back, okay? If you talk to them, you do what I say, you can't afford them, you can't come up with the money, then there's some options for you to maybe get a court-appointed attorney. But you're going to be required to follow those directions first, okay? All right, step in front of the clerk. Justin Payne. Good morning. Good. You're Justin Payne? Mr. Payne, were you able to get someone hired? Who'd you hire? Okay, did he, you've paid him and everything, or you're going to?
No, I had met it now, he said, I had to text me. Says, I had to try some hard comments, so he can back this week.
Okay. So how much more do you need to pay him before? So have you hired him? I guess what I'm saying is sometimes they'll take a down payment for whatever is going to get them on your case.
Mhm.
You've already done all of that?
Yeah, I do.
Y'all didn't hear from him?
I'm working to make sure, Judge.
Yeah, I know.
Well, I think, I don't know if he's on our docket, but I know
He's in Hardin County.
he'll be around there. They're not starting back till, tomorrow.
Okay.
But he hasn't filed anything.
But he's coming today? Do me a favor, just have a seat here in the courtroom until Mr. Kimler gets here. It sounds like he'll be here this morning. Don't leave until we tell you to, okay? Thank you.
Yeah, they're starting back tomorrow.
Okay. Brittany Davis. Good morning, you're Brittany Davis?
Yes.
So Ms. Davis, what happened with your drug patch?
I had a death in my family. I went to Dallas. My daughter got sick and they fell off in the hospital. I have documentation to show where I was when she was discharged.
What does any of that have to do with your drug patch coming
It
off?
fell off and I was in Dallas. I wasn't even involved at the time.
Have a seat in the jury box. We're gonna get you tested this morning. Richard Volry. Good morning, sir. You're Richard Volry. And Mr. Volry, this is your initial appearance in cause number 25 DCCR 1746. You're charged with aggravated assault with a deadly weapon from October 21st of 2025. And since you have made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, sir, is reset your case for about 30 days or so. Give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you a reset notice. Mark Ramirez. Good morning, you're Mark Ramirez. And Mr. Ramirez, did you get a lawyer hired? Mr. Nichols, this is one that I do actually kind of remember this.
Can I get the name here?
It's Mark Ramirez, and I think the complaining witness was going to take the options class or talk to you guys or something. Mr. Ramirez, just have a seat for a few minutes and we'll check on all of that, okay? I do remember something about that. Probably because of other things. To Sean Bass. Good morning, you're Tashawn Bass. And Mr. Bass, this is your initial appearance in each of your cases, cause number 25 DCCR 0832 and 0833. You're charged with aggravated sexual assault of a child from March 14th of 2023 and June 1st of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Bass, is reset your case about 30 days. Let's see. So this is one you were certified as a juvenile. Is that correct? Did you go through family court stuff first? Juvenile? Okay. All right. So I'm going to reset your case. How old are you now? 18. Are you working? Why not? Okay. Give me just a second. You're not still living at the same place with the complaining witness, right? Yeah. Okay, so what I'm going to do this morning is appoint you an attorney, Mr. Bass. Okay, so you'll keep Mr. Rojas as your attorney. No, he's not here yet, but step in front of the clerk. She'll give you his information and when you need to contact him, okay? Brandell Griffin.
Hello.
Good morning. You're Brandell Griffin. And Mr. Griffin, did you talk to some attorneys or get someone hired?
I talked to 3 more. I couldn't get no one hired.
All right, who'd you talk to?
Judge Walker, my son Kyle, Sonia Hickert, and Yes, sir.
Okay, thank you for taking care of that, Mr. Griffin. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct. If you'll step to the clerk on the end, she'll give you that paperwork. Kelvin Johnson. Kelvin Johnson. You don't have anything on him, call or anything?
No response, John?
Let's see, I'm gonna, we haven't heard from him. I think what I'm gonna do, just based on the weather, is reset it 1 week instead of forfeiting the bond. So Kelvin Johnson will reset 1 week. Anthony McFarland. Oh, hi. You're so sneaky.
I know, I ain't on Ramirez, Judge, that's not a case that's gonna be dismissed for doing the class. She did complete it. Our investigator spoke with her and really doesn't think that it's a case that should be dismissed.
Okay, sounds good. I'll take care of it. Thank you, Mr. Nichols.
No response on Anthony McFarland?
I'm going to do the same thing on that case and reset it 1 week. Mr. Ramirez, come back up, sir. So, Mr. Ramirez, the investigator has spoken with the complaining witness, and even though she's taken that class, they are not inclined to dismiss the case. So what that means is you're going to need to get you an attorney. So I'll reset your case for about 30 days to give you some time to get a lawyer hired. If you get someone hired before the next court date, bring the reset notice that you get to them. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers and then bring me their names so I know you're trying and we'll discuss options. Okay, step in front of the clerk. Do I have one for?
They can't.
Oh, they did?
Yes, ma'am.
Okay. David Biano, Ms. Walker, 25 DCCR 1212.
Just seeing him, I'll just call him to make sure everything's okay.
Okay.
So if I could just have a couple of minutes,
Yeah,
I think we're gonna get.
okay.
get this worked out.
I'll hold, let me go ahead. Would you call his name, please? David Biano.
He's standing in front of one of you.
I know.
That's why I got out of the jury box. I wasn't comfortable over.
I know.
I didn't want to be drug tested.
You never know what happens when you get, when you're sitting over there.
Ask me.
You know, yeah.
Justify.
No response, John?
I'll hold it while y'all check into that.
Thank you.
Sure. See, Mr. Morian, you have Carolyn Whitaker,
Yes, Your Honor.
2 cases. I saw him just walk in.
He was walking in, walked back with that. The weather here was not, is not near as bad as it was in Jasper.
No, it's not. And you could have called because
Oh, it could have been, no, the roads were great.
they were fine.
Oh, they were perfect. I drive it one time anyway, so
You're gonna,
I'm all right. It would justify having that.
we
extra
could have
side.
had you pick up some others and bring them down on your way.
I try to keep it to where if I don't show up
Something's bad.
something is bad wrong. You know,
Did we lose him?
yeah, I felt bad. I texted Tom Kelly this morning. I asked him, said, hey, he said, I don't know if I'm clear. I'm rolling.
Yeah, we got our county good. I'll hold it for just a minute. Let me hold it. Mr. Macon, you've got Bethany Loza Diaz. It's a sentencing. This is Mr. Hoffpower's sentencing. It's agreed. If somebody could. Thank you, Mr. Nichols. All right, ma'am, you are Bethany Loza Diaz. And Ms. Loza Diaz was previously in court, entered a plea of guilty to driving while intoxicated with a child passenger. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections? All right, Ms. Loza Diaz, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and then you could go to the state jail prison for up to for that 2 years you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, ma'am, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you. Mr. Paget, you have Catherine Castillo sentencing. Castillo. Oh, yeah. Yeah.
Trinity Bell.
She went out to check on her. She's normally here on this. How are you this morning?
Good, how are you?
Oh, very good. Okay, I was about to say, she's not one I worry about.
So, good morning, you're Catherine Castillo? So before we go further, when I was reviewing the pre-sentence report, there's a new or another driving while intoxicated from July of 2025. Ms. Werner contacted your office, I think, and they contacted the lab. It was waiting on lab. They've pulled the case, and the evidence is going to get tested in the next batch, whatever that means. And so I guess I'm wondering what the plan is on that case. If we need to wait for sentencing on this, if
It may be better.
it obviously gives me some concern that she was on bond for one and
I'm not opposed to that.
got arrested for another.
And it also be another.
Yeah. Yeah. So do you have the auto ignition interlock device on your vehicle?
I do.
You don't? Are you driving?
No, my niece is driving.
Do you have a car? Do you ever drive?
No, I do.
Okay, you cannot, a condition of your bond already is, if you're not aware, you should be. But if you're not, then you cannot drive any vehicle that does not have that auto ignition interlock device on it. I feel like I think I want. The scram device.
And that was a suggestion that Mr. Smith had noted on his PSI as
Yeah.
well, Judge.
I realize that both of those things are probably,
She does work full-time, but the only thing I would be concerned about is the finances.
I mean, it's a requirement to have the auto ignition interlock by law, but I want proof that you have that on your car this week. If you need to get it on your car, you need to send proof that you have it installed to Mr. Paget. If I don't have proof of that by, let's say, Wednesday at 5 o'clock, then there will be an order, number one, that you don't drive, number two, that you wear a scram device. So I want proof of that by Wednesday. Okay. All right. We're going to hold this because we contacted, Ms. Werner contacted your office, and they contacted the lab, and there's a new case, and they're going to have it tested with the next batch.
Yeah. Yes,
I mean, it's in the PSI.
that's the first place I saw it.
Yeah.
First I knew of it, actually.
Yeah. All right. Y'all, you're excused.
Thank you, Your Honor. I
Thank you.
appreciate it. Thank you, ladies. Have a good day.
Just do a normal reset and we'll see where we are. Yeah.
Please turn off cell phones, electronic devices, turn cell phones, electronic devices on. Thank you.
Mr. You need to tell Mr. Griffin he needs to get an attorney hired, or if it's what they're doing, he doesn't qualify. Please, ma'am. Mr. Morian, I'll recall Carolyn Whitaker. Good morning. All right, this is cause numbers 24 DCCR 2182 and 2183. Ms. Whitaker is charged with aggravated sexual assault as well as injury to a child, elderly, or disabled individual. And what's the announcement?
Sanctuary Judge.
We're ready, Your Honor.
Separate trial. I believe there was some discovery that now has been given.
Okay.
On offer, rejected the last time we were here, Judge.
And there hasn't been any change. It was a cap of 40.
Yes, Your Honor.
With a dismissal in the other, correct?
Yes, Your Honor.
All right, so I will get it set on the next available trial docket, and we'll get it taken care of.
Thank
Stay
you.
in touch with Mr. Morian. He'll let you know when you need to be back and ready for trial.
Thank you, Your Honor.
Thank you.
May I be excused?
Yes, sir.
Thank
Take
you.
care. Be
Y'all have
safe
a
going
good
back. Mr. Parker, you've got Angel Coleman's sentencing. Did they get?
Angel Coleman,
Morning.
how are you?
Good. How are you?
I'm good. I got a picture today that fuckers up on all fours about to cry.
Oh, my goodness.
She said she's on the move.
On the move. Things are about to be
Yeah.
get real. Ms. Malfino on Angel Coleman is the sentencing. Good morning, ma'am. Are you Angel Coleman? And Ms. Coleman, you were previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Your Honor.
Are there any additions or corrections?
Nothing over it.
All right, Ms. Coleman, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will actually be dismissed. You'll never be a convicted felon, which is huge, especially at your age. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and I could sentence you to prison anywhere in the range of that punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Could the court also order that $900 in restitution, please?
Any objection to that?
No, Your Honor.
Also, as a condition of your probation, you will be ordered to pay the $900 in restitution. And I want to make sure that restitution at least is paid half up front or with the fees and fines and not put off. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am. Diamond Ollie, that's a sentencing. Something's familiar about this. Somebody sent me an email.
I apologize. What, you asking me something?
No, I'm just, something's familiar. I feel like someone either sent me an email or a message.
I've been speaking with family court on this.
Maybe that's what it is. I can't remember.
Everything's been good, at least from the state side.
Okay.
Through
It was him.
Randy.
Yes,
Miss Kay
okay.
and everything, so-
Look, I knew there was something.
Everything's good. That's all you need to
That's
hear.
all I need to know.
It is. It
Okay,
has been
we're
good.
good.
Everything's good.
That's what I got. Yeah, yes, yes. Oh, that sounds familiar. Perfect. All right, ma'am, you're Diamond Ollie. And Miss Ollie was previously in court, entered a plea of guilty to injury to a child. I've received that pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections?
None more.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, and that includes what I'm going to order is that you can have contact with your child only as approved by CPS. So you have to follow all of their rules, the safety plan and all of that stuff. And so whatever they say is okay, I'm going to rely on them, and you will be able to do it. If they say it's okay, then you'll be able to have contact. If they say no, then it's no. All right, you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
No fine.
No fine. Thank you, Mr. Power. Kira Rogers.
Your Honor, we're asking for a little time on that. I have an offer for restitution, and she thinks she can be able to come up with it.
Okay. All right. So we'll just do a normal reset about 30 days. And so Ms. Rogers, if you can come up with that before the next court date, then we'll see what takes place. If not, stay in touch with Mr. Parker. So we'll see what gets worked out in your case. Okay. You're free to go, ma'am. Caitlin Talmore, sentencing.
Can you hear me? I came in here and I had to go for it. That one, I want to
At
be
least,
here.
hey, there was some feelings hurt. I'm just
I
saying.
came in and told her, she said, go. She told me not to run. Talmore.
Caitlin Talmore.
Hey, George was all warm last night, but he's all snuggled up in that blanket I gave him.
There he is.
Socks, blanket, what else?
And the onesie.
Oh, yes.
For last year. Oh, no.
Good morning. Are you Caitlin Talmore? And Ms. Talmore was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Have, Your Honor.
Are there any additions or corrections?
No worries, Judge.
And so you already are on probation for the DWI from that same date. Okay. All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and sent to prison for anywhere in that range of punishment, which is between 2 years and up to 10 years. Do you understand? All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Parker. Did we get drug test yet? Not yet. See, Mr. Kelly, you have Davin Kalina.
Yes, Your Honor. Mr. Kalina is present, and I also have another case on your docket this morning, Ashley Sanders. She's present as well. Court hold for just a minute.
Sure, yeah, I'll hold them both. Let's see, Brian Lane. Marvin has one. I haven't seen Marvin.
Brian Lane called, he's gonna be late.
Okay. Judge, did y'all hear from Walker? Look, I'm like, Mr. Judge. Mr. Judge. Did you hear from your client? You're not. I said, Mr. Judge. Have you heard from Mr. Biano?
Judge, he's on his way.
Okay, perfect. Thanks.
Thank you.
And what about Burbank? Is he? Thank you. Mr. Crenshaw, Mr. Galmore. Ms. Holmes, are you ready on Maya Sparks sentencing?
1 minute.
Sure. Yep, I'll hold your case. You've got two, Christopher Davis as well. I'll hold those. And wife. And, okay, well.
Give me an idea. On Jonathan Garcia, Mr. Eckert? Sir?
It's a plea. We have paperwork.
Okay, we'll do this and then take it, see where. Get through this and then we'll take you first, okay?
Thank you.
Cody Arnold.
Judge, this is still a trial. Anticipate presentation of this evidence for the state would take us till Friday about noon.
Okay.
With the jury selection starting tomorrow.
Okay.
I'm probably gonna have.
I'm sorry, you
I'm
mumbled.
probably gonna have some witnesses.
Yeah, okay.
We have currently an agreement that an expert witness can appear by Zoom on this one because they're coming from Pennsylvania.
Jimmy's being mean to me Monday.
Okay. We'll see where that's headed. Romero Williams.
I'm trying to work that out. But we're ready if we need.
This is a short one, state's ready.
So we could try this instead of the other one.
Yeah, it's very brief. The as compared to Arnold, it would take me, like I said, through Friday.
Okay. Kobe Rogers. Mr. Batuska. Mr. Ham, you're on that one.
Yeah.
What do you know about it?
I haven't heard from Ryan. That's why I was looking around for him. And then, be candid with the court, I've been prepping on Arnold.
Okay.
This is not one that, I can be ready, but it's not the state of readiness I prefer.
Andrew Kennedy. Mr. Reynolds was just here.
Yes, I believe he went to go talk with him.
Now, on the deck, 10 minutes before board dies. Okay. Okay, that's a way to do it, I guess. Brandon Miller.
Right, Judge, my understanding is his boss sent some pictures or whatever to the court. He represented that it was Brandon Miller. That's, yeah.
That's an email too, saying, and I put it in the file saying that.
What is
he
it?
couldn't get
What
here.
is it?
He's not here. He's living up north and apparently he couldn't get down here because of the winter storm. So.
I disagree. I mean, I know it's kind of difficult, but we've been driving on the streets. Anyway, where is he coming from? Where does he
I
live?
believe it's Minnesota.
What state? Yeah. I mean,
This is my first hearing of that, Judge. I think he should have made preparation to be here, even if it was
We're all-
a little ahead of the
we
storm.
all have. Yeah. I mean, they've been talking about it for a while and everybody knew. Okay.
I don't disagree, Your Honor.
All right.
Well, he's been advised that I can't
Okay.
control what.
I understand. I'm going to ask the bailiff to call into the hall for Brandon Miller. There is no response for the name Brandon Miller. Brandon Miller here in the courtroom. And these are cost numbers 24CR103 and 104. And Minnesota's having to endure. And no response for the name being called into the hall at 9:22 after the 9 o'clock knock began. And how much are those bonds on Brandon Miller?
It's 15,000. First page.
We good.
25,000 on the second case.
Defendant's bonds are hereby revoked as defendant has failed to appear. His bonds are $15,000 in 24CR103 invasive visual recording, and in 24CR104 the illegal possession of child pornography. That bond is at $25,000. Since the bonds have been revoked for his failure to appear, they shall be doubled, and a warrant will be issued for his arrest on those two. And he must have a GPS device as a condition of bond, so we know where he is when he is not here in court, when he is supposed to be. The court, of course, is always willing to change those orders in light of more information about the situation from him being in Minnesota. But he certainly, like all of us, have been given forewarning. And Minnesota is certainly receiving more bad weather than we are. But let me know, Mr. Wilkerson, what information you can get to me.
Yes, I would be.
I will evaluate it and determine whether these bonds should be unremoved. Okay.
I'll get that to you.
Thanks.
Judge, Mr. Reynolds has come out and I think his client is going to be a plea. Can we recall that one so I can verify that one?
Andrew Kennedy, what are you going to do?
Judge, I believe we're going to get a chief plea agreement or. Yeah, it's a plea bargain agreement with the court. We'll signing. Sure.
Does that help you?
Yeah, that's
She's trying to figure out which ones which gun she needs to load up with the ammo. Terrence Moore. Terrence Moore is called. It's Todd LeBlanc.
Judge, I haven't seen Mr. LeBlanc this morning. I'm saying.
Have you heard what might be happening on it? Okay, well. It was kind of,
Judge, if it's this one could go into.
Which one?
The end of the week on Terrace Moore.
okay.
And I just want to report that I do have 2 weeks vacation coming up with a mission trip. I'm thinking I'll leave Saturday. So,
What a tough break.
yeah, so,
What are the odds of that during this long trial?
yeah, so, isn't that amazing? Wait a minute.
Where are you going? Where would you be going? Religious like
Tanzania.
Tanzania? You're not walking.
No, we're
Okay.
we're driving.
Marvin's driving you?
Yeah.
Marvin?
Marvin's
Marvin.
We're not here to grab.
Speaking of Marvin, Travante Nichols.
This one is one of Mr. Boyd's cases. I think Mr. Lee's going to get the file now.
This relates to one, did that, so they can
Trying to see. what
just
he-
affirm where they're at on it, Judge.
Where's Mr. Boyd?
I'm assuming it's the weather, you know.
Really? The weather got him. The weather got him.
Should be.
He was young, too. He was awfully young.
Yeah, I've always liked that guy.
Young, I think, for that.
Yes, sir.
Yeah.
Give us a minute and we'll have.
Okay.
Better enough.
Then we will move Jamichael Smith. No, it's Phillips. I just wanted to see if you were going to continue to stand up like that and respond.
Judge, I believe this is going to be a sentencing.
What he'd like to do is enter a guilty plea and have the jury make the decision as to punishment. So it'll be my preference is that they go ahead and sign documentation about the guilty plea.
So let's get that done.
The question is, do you want to be doing it on both? Because my understanding is that I'm trying to.
We'll just do it as to the voting.
Okay. Okay. Do we need to just say unagreed on paperwork or just bring it in?
You'll.
Well, it is unagreed.
Yeah.
Yeah.
I'm trying to figure out the paper.
Fill out the unagreed
Okay,
paperwork.
that's what I was trying.
But you don't waive you waive a jury trial for the guilt or innocence.
But not for the punishment.
Not.
Let me look, I'll make sure I do it right, Judge.
Wyman Clover. Mr. Adams, Wyman Clover.
He's vaccinated.
He's back there. Are you Mr. Clover? Have you talked to your attorney? Okay, just have a seat. I saw him come in and out, in and out.
Hey, Judge.
Wyman Clover.
And he's next door.
There he is right there.
Oh, I'm sorry. Come on. I need to talk to him about a new one. I thought this was.
He's going to talk to you. Are you through back there on what you're doing? Okay,
I'm done.
go ahead. Let me know. Okay, let's go to page 2 of this multi-page docket. Adrian Williams on Langston. What are we going to do in Adrian before you take off?
Yeah, let me go 1 second on him, Judge.
He's walking back and forth. There he goes. Let's go to Jerome Ned. And
Good morning, Your Honor.
what are we doing? today?
Your Honor, there has
Other
been
than freezing.
an offer relayed. I was informed on Friday that the complaining witness is dead. So that might, require some additional prep work on my part.
Okay. Okay.
And it's too cold to dismiss the case.
There's
My client will get nowhere to do.
sometimes a death does not prevent the evidence from
Oh, I know.
being made and brought forth.
You don't have.
But so what do we do today?
There has been an offer laid. It's my understanding that he does not want the offer, so I believe it's gonna have to be.
Where is he?
Pocket.
Out or in?
He's in
Oh,
jail.
oh.
He's in custody.
Did you want to put anything on the record on Mr. Ned?
Well, Your Honor, he's on parole, so I don't know that he can plead anything anyway. I just, one of those, oh, wait to see what happens with the case. I haven't heard back from his parole.
What's he looking at on the punishment range?
It's enhanceable up to a second degree felony.
Up to 20 years?
Mhm.
And you said the complainant has passed
Yes, Your Honor, that's my understanding.
We got an email to the court.
into to a child or elder. Was it then the elderly person who was the
Yes.
complainant? Okay. Well, I understand.
I don't believe that it
If I
inhibits us.
set this 3 weeks, is that going to be okay?
That's enough time.
All right. I got it.
Thank you, Judge.
Yes. Jarek Holman. Jarek Holman. Have you seen him at all? Jarek Holman is called once.
He just went to the restroom.
He just went to the restroom, according to the audience. Who knows more about him than I do? Well, sometimes that happens,
We come back to it when,
Well, what do you want? What's our plan?
now we're gonna try to work it out and,
Okay, let me know ASAP on one way or the other. Jose Gregorio de la Rosa. That's Mr. Wilkerson. You enjoying yourself on that,
I was, Judge.
with that phone there?
I was.
There's Mr. De La Rosa. And what's our master plan today?
Judge, we are not ready on this one. Since his last appearance, Mr. De La Rosa has saved up a substantial amount of retainer for a digital forensics expert. And I anticipate that he will be hired in the next 2 weeks. Such that what I would request is just in terms of being practical, I think
Yeah, that would be a nice
90
thing.
90 days we would be ready.
Lisa.
But by comparison to the rest of the trial docket, Judge, it's relatively young, so I have no objections.
It certainly is not 4 digits old, but
No, sir. It's not even a year at
what
this
is
stage.
are there any issues of conditions of release that need to be dealt with here?
I think you've done that previously, Judge, but that's
Yeah.
fine.
Remember that one.
I'm going to say no.
With this charge, my concern is involving images of people who may be close to it.
Yes,
That's
sir.
what I'm worried about. Dealing with.
This is
Maybe it's not. I don't know.
the only fear the state has is his internet use is because that's the driving factor on this case. I have no evidence that it involves anybody that is close to him in relationship.
You're saying 90 days?
Yes,
3
Your Honor.
months?
He takes a long time. The expert.
Well, here's what I'm gonna do. I'm gonna reset it. 2 months, okay, 8 weeks, and then it'll be kind of a review.
Yeah, I would ask that so that I can determine if I need to do that.
Get a resetting. Leon Davis
Thank you, Your Honor.
is in custody. And again, have we heard from Mr. LeBlanc at all? Okay. Hector Alvarez was reset. So let me pull all of these that are going to be sets.
Yeah.
Here's your own Ned. And here is Hector De La Rosa. And then that was Jose De La Rosa. Hector Alvarez is this one. Who's ready on a plea? Come on. Yes, on Mr. Garcia. Mr.
Or may take me a moment, but next one.
Okay.
I guess one day I'll get used to this. You want to show me a picture of his family again? Or give you years for the number of kids he has. Yeah. That what you're asking?
Anybody want to read one?
No, Jen.
You know what they say.
He and I have talked about everything in depth.
Well, they certainly were written in depth. Twenty-one 37009 is now called. Are you Mr. Garcia? Please see that lady first. Thank you.
Press your right hand. Where are public truth on selfie bot? Okay, you get your right hand. Place it flat there. You get up one more time. Place it right there. Okay, so go sneak time
I'm a long way here in this case from not being able to speak English at all to very neatly written in English, multi-page document. And you are Jonathan Garcia.
Yes.
And you speak English, correct? Is that yes or no?
Yes.
Okay. Yeah, she has to take everything we say. And this case is called 21-370.
Jill, yes, that's fine.
Well, I thought she was calling it. 21-37009. You were charged with the second degree felony of aggravated assault. You understand that, sir?
Yes.
You were here with your attorney, Mr. Eckert, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
We do, Judge. Anything.
In summary, Mr. Garcia, this indictment, it was handed up a while back in April of 21. We're going on almost 5 years now. And in summary, this states that on or about April 4th, 2021, in Jefferson County, Texas, you committed the second degree felony of aggravated assault. And it states that you intentionally and knowingly and recklessly caused bodily injury to another person with the use of a deadly weapon, namely a handgun, by shooting the complainant in the upper part of his body. Do you understand what you're charged with here?
Yes.
This is a second degree felony under state law, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range?
Yes.
Are you a United States citizen?
Sure.
You're not. Do you understand if you are not a United States citizen, a plea of guilty may result in your deportation,
Yes, sir.
exclusion from admission to the United States, or denial of naturalization under United States federal law? Do you understand the
Yes.
risks that you take?
Yes.
Okay. An agreement has been reached in your case where you would be pleading guilty, sentenced to 6 years in prison. You will be given credit for all time you have served in accordance with this case. Is that your understanding of the plan? If I follow this agreement such, you have no right of appeal of your case. Do you understand? Today is January 26, 26.
Yes, sir.
How do you plead, sir, to this charge, the second degree felony of aggravated assault in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this states? I'm going to show you with your attorney what is marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in this case. All of this is true, it states. So help you God. Correct. All right, your State's Exhibit 1 is made a part of the record without objection.
Without objection, Judge.
It is so done. Pre-sentence report is waived here.
Yes, sir.
If nothing further to add, I am going to follow this agreement that has been reached here, Mr. Garcia. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the second degree felony of aggravated assault. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Additionally, the court is going to make a finding that based upon the allegations in the indictment for what the defendant has pleaded guilty to, a deadly weapon, namely a handgun, was used in the commission of this offense, and it will be so rendered as an affirmative finding on the judgment. Do you understand what has happened today, sir?
Yes, sir.
Okay. Stand by just 1 minute, please. Let me just look at one thing. You have a family, where?
Arlington, Texas.
Argentina?
Arlington. His wife and children live in Arlington, Texas.
Oh, Arlington.
She is a United States resident.
So why were you here in Beaumont, Jefferson County? Why weren't you living in Arlington when this happened? You were here at work, working?
Mm.
What were you doing? What work do you do?
Constitution.
Construction. He works concrete, Judge.
You know, your family is very important. This is what I'm reading here, that you say this in your letter,
Yes,
and they are. That's why it's very important when you make decisions. You have to consider how that might affect the people you care for very much. Who wrote this letter? You've signed it. Did somebody help you write this?
yes, ma'am.
Okay,
But, I'm making a fun somebody from.
okay, and they put it in English.
Right.
This is like the same letter. Just rewritten and. All right. Is there how much credit does he have?
Judge, he has about a year and 3 or 4 months, I believe.
Really?
He was on bond initially, and that bond eventually.
Dallas County, wait for.
Dallas County?
Yes, some kind of.
Well, you will be given credit for all of that, but because of the crime that was committed, because a deadly weapon was used, you must have credit for 1/2 of the sentence. So 1/2 of 6 years is 3. You have to get credit for 3 years. You're well toward that, but it may be a little while longer before you can be released. But I think they normally do that when it reaches that half point, that halfway at 3 years. Once you get that, they're going to get you released. Okay, take care of your family.
Thank you, Judge.
All right. Thanks. I have Andrew Kennedy. Mr. Reynolds?
He needs to be fingerprinted, Judge.
Yeah.
He'll put his nose in this.
Kennedy.
We're seeing back in water.
Well, that one was an old one.
27 months.
Thank you.
What is he, there's 3 cases. What's he going to be pleading
He's going to
to?
be pleading to the sexual assault and the.
Indecency by exposure.
And then a third case, indecency with a child, will be dismissed.
That's correct.
Yes.
He needs to go in front of her? Okay, thank you.
Right here, square walk up, 23, then I do the toothbrush up, because your right thumb print. Place it flat right there in the box. Okay, you get it one more time, same one. And flat right there. Okay, go stand in front of the judge.
And you are Andrew Kennedy, sir?
Yes, sir.
3 cases are called 1769, 1770, 1771, and in numerical sequence, 1769 alleges that you committed the 2nd-degree felony of sexual assault of a child. 1770 alleges you committed indecency with a child, and that is a 2nd-degree felony. And then a 3rd-degree felony is alleged in 1770, 1771, and that is indecency with a child in that case, and that is a 3rd-degree felony. So in the 2 2nd-degree felonies, you were looking at no less than 2 nor more than 20 years confinement in prison, and in the 3rd-degree felony, that is up to 10 years in prison. So a total of 50 years in prison is at issue here in these 3 cases. So it's my understanding you are going to be pleading guilty to 1769 and 1771. Sexual assault of a child, 2nd-degree felony. And the third degree felony of indecency with a child.
Judge, on the third degree felony, I think I checked the wrong box.
That's okay. We can fix it.
Okay.
And then in 1770, that second degree felony of indecency with a child will be dismissed as part of this agreement. Was that your understanding of the master plan, sir?
Yes.
You should. So you were here with your attorney and the state's attorney. Mr. Reynolds, does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
He does, and you major.
Okay. In 1769, 23 CR 1769, in summary, sir, this alleges that on or about December 22nd, 2022, in Jefferson County, Texas, you committed the second degree felony of sexual assault of a child. You understand what you're charged with in this case?
Yes.
If convicted, you were looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 10 years imprisonment. This would run concurrently with the 23 CR 1771 case, and 23 CR 1770 will be dismissed as part of this agreement. Is that your understanding of the agreement?
Yes, sir.
If I follow all of this, you have no right of appeal of your cases. Do you understand?
Yes, sir.
How do you plead in this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'm gonna ask the prosecutor, something happened on that. I don't know what happened there. Well, just please sign. Thank you. Somebody leave these pads out in the cold last night. They're really acting funny.
There's a delay, I've noticed.
In 1771, sir, this indictment is a third degree felony, indecency with a child by exposure. And it was checked off as the second. I'm changing it to the third.
Yes, sir.
Which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that, sir?
Yes, sir.
The agreement in this case is you would be pleading guilty, sentenced to 10 years in prison to run concurrently with the previous case that you pleaded guilty to. And then cause number 1770 will be dismissed as part of this agreement. We are getting new pads this year, right?
Text Mary Helen and asked them. We were going to.
Did you told me that?
I'll let you know.
You told me that 6 months ago. All right.
I'm getting an update as the nothing judge.
Hasn't been a year yet.
It's like Santa didn't show up for Christmas. I'm a little upset.
Well, maybe we didn't make the good list.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead on this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 for each of these two cases you have pleaded guilty for. Did you sign those documents voluntarily? Understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection, admitted. Among other things, this states you, in each case, State's Exhibit 1 states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial, the appearance of counsel, and the cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record in each case. Pre-sentence reports are waived here.
So wait.
I will follow the agreement. I will follow this agreement and make the following findings in each of these cases: that you are pleading guilty in each of these two cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of each of these two cases, sir. And I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each of these cases. And these sentences shall run concurrently with each other. Do you understand what has occurred today, sir?
Yes.
And 23 CR 1770, that case will be dismissed as part of this agreement. Do you understand? Anything else to add on this?
He gets credit for his.
Yeah, of course he does. He gets credit for all time he has served in accordance with these cases. Also, do you understand? There are certain requirements now that you must have. You are now a sexual offender under the laws of the state of Texas, which means that you have to register as a sex offender because of each of these two cases that you have been found guilty of. Failing to register properly can result in additional felony charges being filed.
Yes, sir.
And you could be then sentenced to additional punishments for felony offenses. Please make sure that you understand the requirements and you follow them.
Yes.
Anything else to add?
No, sir.
Okay, thank you. That is all. Good luck. I'm going to also, I think there is it's a dismissal. I don't see it yet. When the dismissal shows up, I will sign it.
Okay.
So, Mr. Kimley, what was your take on those last pleas? I know you were closely following them. Well, how do you think that all resulted?
You're gonna have to register if you have no other things. So that was the state made the best offer they thought.
I see.
Boy, is having the child having us. That was cool.
Do you know you snore when you sleep?
It's silent.
You still snore when you sleep.
I'm not.
We all saw you. No, hey, you can do it. You weren't up to bat yet. Just don't do it when you're up here and then fall down or something. All right. Jamichael Phillips.
Mr. Burbank also has a plea, Judge. Mr.
On,
Yeah.
Right now.
okay, yours, come on up.
Which state?
Romero.
Dwayne.
Mr. Williams, I think we can fingerprint swear.
Phillips, Judge.
See him?
Oh, here.
They're still signing up, Mr.
Yeah.
Please raise your right hand, you square or firm, kind of the cultures, and nothing but the yourself you got. Okay, with your right thumb, right thumb. Yeah, there you go.
And there's you.
Flat right there on the box. You get up one more time. Okay, same one. Is it flat right there? You go stand.
23 CR 1039 is now called the State of Texas versus Romeo Williams. Is that you, sir? Yes, you have to speak out so she can.
Yes.
Okay. Mr. Burbank is here representing you. The state's attorney is here. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, and you may, Your Honor.
In summary, this indictment alleges that on or about June 6, 2023 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by a felon. Do you understand what you're charged with here, sir?
Sir.
Okay. It's a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where you would be pleading guilty. Is this 5? It's not.
I thought he said 2. 2 and 5.
So you wrote it, a 2 and a 5 together. Yeah. It's like whatever sentence shall not exceed a cap of 5 years in prison. So you were looking at no less than 2 nor more than 5 years confinement in prison. You could be placed on deferred or unadjudicated probation for up to 10 years in length. Also, I guess regular probation is an option as well. You could be sentenced to no less than 2 nor more than 5 years confinement in prison, and that could be suspended and you could be placed on regular probation. Do you understand your options here? If I follow this agreement, sir, you have no right of appeal. Make sure you speak out so she can, the court reporter can take, they have trouble on nods and. All right, again, if I follow this, you have no right of appeal. How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will
Yes, sir.
and because you are guilty.
Yes, sir.
Okay, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection.
No objection.
Admitted. Among other things, this states you are mentally confident to enter your guilty plea as freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report will be prepared.
Yes, Your Honor.
And we will come back another time and everybody will add whatever else you want to add to the record and then the court will make its decision. Please get a resetting from that lady. Thank you.
If you excuse that.
And the probation office is going to be contacting you. Make sure you participate with them and give them all the information they need, sir. Thank you.
See the probation officer.
Here it says, thank you. I have a equivalent tree. Come on.
That's fine. March 6th.
Mr. Burbank, any update on Cody Arnold?
I know he's in custody.
Okay, there's nothing changed.
There's nothing changed on that, except that it may go past this week.
the state's case will take till Friday. If it goes smoothly, I anticipate it'd be done by noon on Friday.
Are you on Kobe Rogers? How are y'all on that one? Ready?
No, I'm not at the level of readiness I would prefer because I've been working on Arnold, Judge.
On what? On Arnold?
I've been working
Yeah.
on Arnold instead of Rogers. With Phillips, we should have a plea and be prepared to take that to the jury for punishment. And I haven't heard Langston's announcement on his 3 cases on the
Are y'all ready on Leon Davis, on Mr. LeBlanc's case?
Jake's ready.
Okay, how long would that take? I'm sorry?
I haven't seen it.
Oh, no, we hadn't seen him on any of these. That's at least 2 of them on the docket, and one's a murder case. Could you call Mr. Long and ask him please to show up? Okay, and Marvin? Where'd Marvin go? He's in the back. On Trevante Nichols. Thank you. Hey, Marvin, on Trevante Nichols.
Yes, Judge. I talked to Mr. Lidd a little bit about it.
I'm sorry?
I talked to Mr. Lidd a little bit about it.
Yeah, how'd that go?
But I think we're gonna have to get with Mr. Boyd on it.
Yeah, Mr. Boyd is the record.
If
attorney.
we can get a few weeks.
How much?
We can get 4 weeks.
Is 3 gonna be good?
Oh, 3 is good.
All right, on Trevante Nichols, we set 3 weeks. Here's one.
Yeah, the 6 paperwork on Phillips.
3. Jermichael Phillips, come forward. I have 2 cases. One's to be dismissed. Or,
If you're up to me, yes, Judge.
okay,
can't-
okay.
I think the other one's just going to be held in abeyance depending on what happens with the Beatles.
Jermichael Phillips.
Have a final please.
So he's gonna plead on 307.
Correct, Judge.
Jermichael Phillips, is that you? Please see this lady first. Thank you.
Ms. Phillips, please raise your right hand. Do you swear or affirm to tell the truth, the truth, and nothing but the truth, so help God?
I don't understand what this says down here at the bottom.
Yes, as to guilt innocence only pertains to sentencing. I'm trying to make it.
One more time. Same one. Place it right there.
It's the,
This thing?
You stand in front of judge.
and that's because I just wanted to make sure it was enhanced from a third to a second. Just noting it on the paperwork.
24 CR 307 is called the State of Texas versus Jermichael Phillips. That's you? Yes, you know, you need to speak out so she can hear you. You are Jermichael Phillips.
Yes, sir.
And in 24 CR 307, you were charged with a 3rd-degree felony of evading arrest or detention with a motor vehicle. And Mr. Turk is here representing you today, correct?
Yes, sir.
Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about January 12th, 2024 in Jefferson County, Texas, you committed this 3rd-degree felony of evading arrest or detention with a motor vehicle. You understand what you're charged with.
Yes, sir.
There's a second paragraph that also alleges that on December 17th, 2019, in this criminal district court in cause number 19-30956, you were finally convicted of the 2nd-degree felony of robbery. Is that true?
Yes, sir.
Paragraphs 1 and 2 would constitute a 2nd-degree felony punishment if you were prosecuted for both of those and the jury finds those to be true beyond a reasonable doubt, which means you would be facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What does this say at the bottom here? What is
It's
that?
just enhanced. It's the notation that it was, you can erase it, Judge. I just.
Okay. All right.
It's just a
Is
note.
it enhanced to second degree, right?
Yes, Judge, that was
Okay, that's
the
what. It was just abbreviated. and-
Yes, sir.
Yeah, I couldn't, it looked like,
Sometimes I do what the pen allows me to do.
yeah. Looking forward. We all at its whim.
So we can go.
Okay, what's our plan on this?
Judge, my understanding is Mr. Phillips wishes to plead guilty, but he would like a jury to assess the punishment.
Okay, so there is no agreement.
Correct.
And he's ineligible for probation in front of a jury.
Right. Yes, Judge.
Okay. That's the way to do it. So how do you plead to this, sir, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily to this third-degree felony of evading arrest or detention with a motor vehicle, as alleged in paragraph 1 of this indictment? And are you pleading guilty because it is true as it is alleged?
Yes, sir.
And paragraph 2, which alleges you were finally convicted of the second-degree felony of robbery on December 17th, 2019, in cause number 19-30936 in this criminal district court of Jefferson County, Texas. Is that allegation true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
All right. If found guilty, do you understand you are facing a third-degree felony based upon paragraph 1 of the indictment? And if paragraph 2 is proven true beyond a reasonable doubt, then that punishment range can be enhanced to a second-degree felony, as we've talked about here in the accordance with this plea, where you are looking at up to 20 years in prison.
Yes, sir.
All right. How do you plead? Again, in this case, are you guilty of paragraph 1 and true to paragraph 2 of this indictment, which constitutes a third-degree felony, enhanced punishment to second degree?
Guilty.
And are you pleading guilty and true voluntarily? And because all of this is true and correct as it is alleged?
Yes, sir.
You understand? That you have given up your rights to a jury trial as to the guilt or innocence phase of this case by entering your guilty plea.
Yes, sir.
You have reserved, though, your appeal, if you wish, as to what punishment may be assessed by the jury.
Yes, sir.
It was marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. And this states that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial as to the guilt or innocence phase of this case, and the right to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. Yes, the State's Exhibit 1 tendered into evidence without objection. And again, how do you plead to paragraph 1, charging you with this third-degree felony of evading arrest or detention, guilty or not guilty? Yes. And to paragraph 2, are you pleading true to that allegation of commission of second-degree felony robbery on December 17th, 2019 in this court? Yes, ma'am. Or you're entering your pleas voluntarily, knowingly, intelligently, and because all of that is true? Yes, sir. Find that you understand and appreciate the consequences of pleading true. Anything else to add?
Judge, just real quick, I just want to make sure the record's clear that Mr. Phillips and I have discussed the options between presenting sentencing to the court and presenting to the jury. And he is one of the key distinctions being that the court can grant probation if the court found it warranted.
I can grant deferred or unadjudicated probation.
Correct.
That they cannot, a jury cannot.
And so, and Mr.
As well as straight probation. The court can.
Yeah. And
where the
because
jury cannot.
Because he has a final conviction, then he is ineligible for probation in front of a jury.
And I was just making sure we discussed that correctly, Phillips.
Okay. Yes, sir. Okay. You understand all of that, and you, knowing all of that, you insist on pleading guilty to the court and asking the jury to assess the punishment in this case.
Yes, sir.
Okay. Then I find that the defendant is pleading guilty voluntarily. He is mentally competent to do so. He understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I find you guilty beyond a reasonable doubt of that offense. And we will move forward to the punishment phase of this trial. When can we set that? Yes, that's what we would do. We need to move it to a court docket to get it done.
Does your honor want to consider it for tomorrow?
No, I got other things on this one this week.
Yes, sir.
Nothing else. We'll figure it out and get back with y'all. Okay, but we will be done as soon as possible. Yes, sir. Thank you. Wait, Tom? On Mr. Ham, what would you say on Kobe Rogers?
I said it, not as ready as I would like to be.
I see.
I've been focused on Cody Oil.
Yep. How long on that one? How long is Cody Arnold?
Tony Arnold is the one that if everything goes smoothly, I can be done with it by noon on Friday.
Okay, and Tom, I lost Tom.
He said he anticipated defense witnesses, Judge,
Mm-hmm. Yeah.
but he didn't indicate number.
And it, well, Mr. LeBlanc never showed up today. Did we ever call him and come? Because are y'all-
Responded.
Mr. Larry, are you ready on that? Terrence Moore? And
Judge, I can be, but I told you that I can't, if it goes into next week, I can't complete it because I'll be gone Saturday. The Tanzania.
yeah. What do you think? It's a murder case.
Yes, sir. It's iffy. I can't guarantee it.
Langston?
I'm
Is
here.
here.
I got a plea off the trial document.
Which one?
Malachi Harris is plea on the trial document.
Are you ready?
I sent it to you.
Come on up. Get that one. Okay, on
That's on the trial document.
on Leon Davis. Y'all ready on that? Stay ready on Leon Davis?
Your Honor, we have a witness out of town and due to weather, we're not gonna be able to do that this week.
Oh, Langston, what are we doing on Wyman Clover?
He's here and he wants the trial.
Are you ready on that?
I can be ready on that one.
Your Honor, that's the one that our complaining witness, you know.
Well, I thought, okay.
That's what he said. Yeah, I can be ready on that one.
Here's, there's a right hand, which is or front, then free the whole through, kind of nothing but the hots. Okay, you have your right thumb print.
This is Harris, that's the plea on trial document.
Like right here. You have one more
Oh,
time.
there was,
Malachi Harris is the plea.
State is ready on Leon Davis, Judge. I'm sorry. I'm in closure, guys, and out of town.
okay, you're ready on Davis?
Yes.
Okay, we'll call that one. And then I'll do a backup on that one.
Got Adrian Williams before that, the state's ready on that.
Yeah.
He's in jail, it's a judgment arm,
Two.
Adrian Williams.
Yeah. And then 3, just to be on the safe side. On Wyman Clover,
I'm ready on that one.
you ready?
Yeah, I can do cool.
That's the one she's missing the complaining witness on, I believe, Judge.
All right. And then on Mr. Ham on Kobe Rogers, we're postponing that one, right?
Yes.
Yes, please, Jeff.
What about Jarek Holman? Are y'all ready? Can you go on that one?
Which one, Jeff?
Jarek Holman with Burbank, illegal possession of a firearm.
Good judge. I'm ready on that case, and I'm also ready on Adrian Williams above that.
Okay, Davis is first, Williams is second, Jarek Holman will be third. And then we need to get the Arnold and Rogers and Moore, they'll reset very quickly. Those are very serious. And then Clover as well. Okay. Oh, this is Jamichael.
Harris.
Malachi Harris.
Hey. Here's Phillips's 2 cases. Malachi Harris. 24 CR 1329 was called the state of Texas versus Malachi Harris. That is you. Present with your attorney. Mr. Adams and the state's attorney does the defendant waive a formal reading of the indictment and arraignment can we proceed in summary?
Yes, sir.
In summary, 24 CR 1329 alleges that on or about April 28th, 2024 in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted of a first degree felony, you face a term of life imprisonment, or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached in your case where you would be pleading guilty, sentenced to 8 years in prison, given credit for all time you have served. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Would you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No,
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is way to it.
Yes, sir.
Anything to add by anybody?
Nothing further from the state judge.
Okay. Anything you would wish to add, Mr. Harrison? I'm going to follow this agreement
Yes, sir.
and find, if nothing further, you have pleaded guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And the judgment shall reflect affirmatively in a finding by the court that a deadly weapon was used or exhibited, namely a firearm, in the commission of this offense. Do you understand what has happened to this?
Yes, sir.
Anything else to add? That is all. Thank you. Oh. Here we go. Thanks. Who's the attorney on this one, State?
I think that's Tall, if I'm not mistaken. Yeah, Tall. The line doesn't.
What do you want to do about this?
Judge, I think out of abundance.
Have you given a copy to him?
That's in their discovery, so they got, but he can look at it. That's what they produced to me.
What is it, Judge? It's not my case.
It's the emergency detention because he was suicidal. If you look right here.
Yeah, so.
Right here's what I'm worried about. Read that.
Okay, so what are you asking?
Just what I was gonna do is to ask for the form and get him tested. Because that was at the time of the incident.
You're doing it for sanity, or has he been competent with you?
No.
What are we doing?
Exactly at the time.
Okay.
Yeah, turn that off, please. Big shoe. He has 1, 2, 3, 4, 5 prior convictions for intoxication. Yeah. We don't think that that might be a significant factor in all of this. Anyway, you were looking at no less than 25, no more than 99 years confinement or life imprisonment in this case. Do you understand? I'm talking to you, sir. Do you understand? Speak. Thank you. Any objection to the defendant's request for
No, Your Honor, just
an
to make sure.
evaluation for competency or insanity and or insanity? But the court would note that these numerous convictions for alcohol related, I presume alcohol related, it could be other type of intoxication, may or may not have been a factor in the actions taken by this defendant, but we will let Dr. Rapon get to the bottom of it. Okay. And that will be done. We will send a request for an evaluation. Jose Buendia. Jose Buendia. We're going to do on this one.
Judge,
Jose.
I spoke to Mr. Nair on that one.
Yeah.
And
He's a second-degree felony, but it's an enhanced with a robbery. He's looking at first-degree felony punishment here.
this is the one, Judge.
What about?
I just wanted to just look at what I pointed out. I had spoken to Mr. Laird about this case. He was transported on the date of the incident to Baptist for a psychological evaluation on that. Mr. Laird and I both agree that he too should be tested. Not talking to Mr. Laird.
All right, done. Then an order for evaluation for competency is going to be requested of Dr. Edgar Pond, licensed psychiatrist, and we will return back. Patrick Peshoff. Here's this, Patrick Peshoff.
He's telling me he's not taking anything, but I told him to talk to you. He said he's not.
That's okay. That's what we do.
I say it's better to
over 600 times we've done trials. I'm happy to say. That doesn't stop people from exercising their constitutional rights, which are very important. I need the file on Patrick Peshoff, please. Peshoff.
You can tell him that.
25 CR 1469 is called Patrick Peshoff. Is that you?
Yes, sir.
You were here with Mr. Adams, your attorney and the state's attorney. You You were charged with a third-degree felony of harassment of a public servant. If convicted, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What are we doing on this?
The offer is 4 years. When I gave you the 4-year offer with the police report and discovery, what's your response?
So I'm going to take it to trial.
It's done. When can we be ready? It just looks like this. Okay, set this special set trial 4 weeks. Thank you. James Franklin. Anybody here on, I haven't seen Mr. Gertz all day.
That's reset, Judge.
Those are reset? Or all of his reset?
Yes, and Mr. Jeffrey's dates were reset.
Ashley Nelson's charges with Benjamin Jeffrey, that was reset. Marvin, Ricky Sloan
Yes, sir. She says,
on Marvin. You ready on that?
I am due.
Okay.
Oh, sorry, I didn't know that.
No, it's Ricky Sloan the third. 2 cases, should have 2 cases.
Judge, it was on your desk. Did you bring it in?
Yes, I did.
Okay.
There it is. Mr. Matuska, where are you? In and out. Reagan? Minaldi?
I did see Reagan. Oh, she was.
Huh?
Cricket.
Brent, no, don't go anywhere. I'll put you up next.
It's like that.
We now call good work. We now call cause number 23 CR 738, the state of Texas versus Ricky Sloan III. Is that you?
Yes, sir.
Present with your attorney, Mr. Lewis, and the state's attorney. All right, earlier, the defendant has entered a plea of guilty to this first-degree felony of aggravated robbery in this case. And a pre-sentence report has been prepared. If the parties had an opportunity to review it, any corrections or changes to it?
No, sir, not from the campus.
Nothing from the state.
It's made a part of the record for all purposes. All right, the agreement is whatever sentence shall not exceed a cap of 13 years in prison. So we are looking at no less than 5 nor more than 13 years confinement in prison. The defendant can be placed on deferred or unadjudicated probation, but is not eligible for regular probation because a deadly weapon, namely a firearm, was used in the commission of this offense, which resulted in the complainant or victim being shot. All right, the state may open and close.
Yes, sir. Does the court have a copy of the letter from the defendant?
It should have been attached.
It wasn't with my initial plea. I mean, with my initial PSI, but it did come.
Yes, that's it.
Okay.
Mhm.
So Judge, I reviewed the letter from the defendant and I was convinced to actually give him a second chance and agree to the probation. But that was until I considered page 2 of the PSI and I looked at his behavior over at our jail. And in the defendant's letter, he claims that his son was born on November 16th of 2023, and then he lost his dad in December of 2024 while he's been in jail. And he says those things basically were an eye opener and helped to change his line of thought, and he's going to get out and be a better person. But his behavior in the jail says differently. And there it says he's been getting in trouble. There have been several incidents since September of 2023 through November of 2025. Physical altercations, threats to staff, refusal to comply with directives, and possession of contraband, smoking marijuana inside the dorm.
Hello.
2 separate fights, one in June of 24 and March of 2025.
That's kind of a crime, isn't it?
Yes, sir. So that means his promises in this letter were just written here, but he's not doing that over at the jail. So the state, we had a cap of 13. The state is going to ask that the court sentence him to that 13 years TDC because his behavior is clearly showing that he's not ready to change.
Okay. State, is made a statement. What says defense, Mr. Lewis?
Well, just to those direct statements there regarding his behavior in jail.
Will you disagree with that? That's in the report.
I don't necessarily disagree, Judge, but I think that they were mainly doing the beginning of the sentence. When the majority of these write-ups occurred, there was one from I think about 6 months ago in November, but it dealt with, it would be something that probably be considered minor, considering some of the other situations, things that was been going on at the jail. And a lot of that has been through from him realizing, of course, the situation he's in. A lot of the things from Mr. Sloan, will just point really at the PSI when you talk about his one criminal history. He doesn't have any juvenile history, very little adult history. He has some cases that were dismissed, but then, of course, this current pending case. You will see that up until about 6 months before this happened, he was really on a pretty good track or path. He graduated from an early college program here, and an honor student, A's and B's, not missing school or anything, held his own job. All of these things were going on until about 6 months before this happened. Now, and of course, like I said, he got off track. Admittedly, he did. He's honest about that as far as him understanding the situation he put himself in, his family in, and everything like that. Now, of course, there were things that happened while he was in the jail that had big impacts on him. Like I said, the death of his father, which came through a tragic accident while he was at work. Then, of course, the birth of his child. So, him being in jail and not being able to be there for his family, in those instances were definitely eye-opening experiences for him to take full advantage of any opportunities that may be available to him in the future. He does understand that, even if the court decides that community supervision or probation is not an option for him in this situation, it doesn't take away his desires or his plans for when he's released. He still is looking forward to trying to move forward, take care of his son, be there for his son, and not let his father fall back from passing away like he did. He does have a definite plan, support system that includes his fiance, which is the mother of his child, who's been there supporting him since this all started. There's letters of information there regarding his aunt, who's a retired educator. She's been involved with him since the beginning there, Judge. And also, of course, his mother. She's been in close communication with me throughout this process, and is more than willing to help him as much as she can for us going forward. So we know it's a big ask, Judge, but we are asking that he place on community supervision so he can carry out those things. He, like for example, even his education as far as he was a student at Lamar at one point. He wants to continue that, and he just wants that opportunity and wants to be able to show you that he's not going to let you down. That's it.
What do you want to say, sir? This is your opportunity if you want to say anything, Mr. Sloan.
I take full accountability of everything I have did with my father dying, with my son being born while I was in jail. That was an eye opener to me. When I did get in the county, I was getting in trouble with as when things started to happen. I started to change. I'm going to go better. I want to be there for my son. I wasn't like years. I want to apologize to the courtroom. I want to apologize to the victim, his family. I want to apologize to my family. I want to come to bed if I don't want to walk down the straight line home. This is not for me.
Sir,
So this is not for me. I want to walk down the straight path. I don't.
but you didn't. You made numerous mistakes here. Plus, the child, the mother of the child was pregnant with your baby when this happened, right? So you knew that you had a child coming. Your father, you had a father who was existing at the time you did this. Well, don't hide behind them and for your responsibilities. You had a father to live for and to do, to impress and to make proud.
Yes.
And he passed. You had a child on the way. All you're saying is my father died and the child's born, but you had all those things already. And yet you made these terrible mistakes. Here, you're lucky you're not here for capital murder. The man was shot who you robbed by you. If he'd have died, you've been looking at two things: life without parole or the death penalty.
Yes, sir.
You wouldn't have a chance for getting out of confinement in a cage the rest of your life or being executed. And you're apologizing, but I don't know what you're apologizing for, because these are clear mistakes, clear right versus wrong. And just by the grace of our Creator, you're not on death row.
So,
But that didn't make Mr. Sanchez, the man who was shot, how many times? Let me read this. Let's see. Shot numerous times. Somebody unknown to him, you tried to rob him, and you said, "Give me what you've got." You had an AR-15 style rifle, and he's cooperating with you, and you still shot him for no particular reason. Then the victim tried to grab the firearm and shoot back in self-defense. And then several suspects with you, others with you, began shooting at the vehicle he was in. And he was he was transported to St. Elizabeth. And then it was discovered you had been shot in the left hand. They located the AR-15, the police did, in the apartment that you went to. A third victim of the shooting showed up at St. Elizabeth by private automobile. He had a gunshot wound to his left buttocks.
yeah.
Yeah.
We started my dad Saturday.
We're having a shootout here again in Beaumont. Like it's the Wild West, chaos. Meanwhile, you've got a child on the way and a family, but you're right in the middle of this shooting people and taking money. You see anything wrong with that?
Yes, sir.
Yeah, I do too. And several relatives wrote letters on your behalf. as well as others. Uh, who were trying to help you. Unfortunately, they can't undo what you did. And that is while a grocery store delivery man was delivering items in his job, you ambushed him and shot him as he was trying to defend himself. And the victim sustained multiple gunshot wounds, but nonetheless was able to escape in his vehicle and call for help. Shot him numerous times, and only the grace of God kept him alive, not you. You were there to kill him. And when you had a chance to discuss all of this with the probation office, you say, I was in the wrong place at the wrong time. Didn't want to give up much about you shooting the man numerous times and taking his money. During your time here in jail awaiting the disposition of this case, you have shown a consistent pattern of behavioral issues, physical altercations, threatening staff members of the jail, refusing to comply with directives, and possessing illegal contraband, including drugs. Refusing to follow orders, being disrespectful, threatening language toward officers, engaging in gambling activities, threatening an officer by stating he would slap her where she had to call for backup, hiding unauthorized items such as extra jumpsuits, tissue rolls, smoking marijuana inside the dorm, but despite multiple warnings and explanations of facility rules, you know actions have consequences. You were arrested. You have a child on the way. You shot somebody numerous times. If dead, that would have been capital murder. And so you're up to, despite warnings by the staff, you continue to disobey the jail requirements. 2 separate fights, attempting to stop another inmate. And overall, the probation office states that all of this portrays a defendant with a high risk history of aggression, repeated rule violations, disruptive conduct requiring frequent intervention by correctional staff to maintain order and security within the jail. And you consistently undermine institutional rules and pose challenges to staff authority and dorm stability. Well, at the end of the day, that doesn't look like somebody who has potential for success during as a condition of probation if you were placed on probation. And then here you are telling me all the things that you have to live for, and yet you have been consistent in disregarding all those blessings that were given to you. The greatest blessing given to you is the man wasn't killed, or you'd never see the light of day as a free man. But here you are. Anything else to add by anybody?
Nothing further from the state judge.
Yes.
Okay. And anything you would like to add, Mr. Sloan? The court has reviewed the file thoroughly and the letters on your behalf by relatives or associates or acquaintances. You were looking at at an agreement of a cap of 13 years in prison. If nothing further to add, I'm going to find, Mr. Sloan, you have pleaded guilty here voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery with the use of a deadly weapon, namely a firearm, by shooting the victim with a firearm in the commission of this robbery. I am following this agreement after being found guilty beyond a reasonable doubt. As I so find, you are hereby sentenced under this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 13 years. You will be given credit for all time you have served, and the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You understand what has happened today? Yeah, you're nodding. That's a yes, I presume. You're going to send me a motion to dismiss the other case? Is that our plan?
Yes,
You've
sir.
waived appeal on all of them.
Yes, sir.
Okay, then the other case will be dismissed, the third-degree felony of deadly conduct, which carried with it up to 10 years in prison. That will be dismissed as part of this agreement. You could have been found guilty on both of these, and also those could have gone consecutively as well. Anything else?
Nothing
That was all. Brent, you had Trevon Cunningham?
Yes, sir.
I'm gonna
Just got to offer on that one. May need some time to discuss it, but he also told me he had not been
He had not had been what?
arraigned on this case.
Well, if he's gonna plead guilty, that's what we would do.
Well,
We do it.
I just really got an offer. I'm just letting you know, kind of. So
But,
anyways,
I mean, that's odd because they never missed that.
well, I think what might have happened is they aggregated in some things into a continuous, and maybe they haven't talked to him about that. I don't have. Mr. Boyd here is discussing.
Well, whenever a warrant is issued, I mean, they go before a magistrate. That's always the case.
That's true.
Anyway, what do you want to do today?
Judge, can I reset him to visit with him some more about this case?
How much time?
4 weeks, 3 weeks.
He was arraigned in front of,
I mean, I believe you.
I'm sorry.
yeah, he was arraigned in front of Mark Road. It's in the jail notes, so.
Okay. On the continuous? Okay.
That's the only one I've got. I just have
Yeah.
one on him.
Well, he mentioned something about other cases, so I'm just trying.
Other cases.
I'm just trying, I guess, Mr. Boyd's not here to clarify.
Okay, reset 3 weeks, okay?
Yep.
Robbie Guillory.
He's gonna be a plea judge.
All right, I need Mr. Guillory. Thank you.
And then Mr. Jones, I can hold on him. I might be able to get that resolved today.
Yes, sir. Thank you. And
Mr. Smith is in the hospital apparently, and then Mr. Watson has an offer that.
hold on Christopher Smith. He's not here.
He's in the hospital from what I understand. He's incarcerated.
Okay, I just wanted verification from the
That's
jail.
not-
It's not here, so we can reset it.
Sir, on whisper to see if there's no turkey coming on this other case.
Okay. I'll just.
Letting you know.
No, no. They would be.
First to call, I think we need to call LeBlanc and tell him he's the focus of attention on the trial.
Says red, so he read my text message.
Okay. Okay, who are you, sir? Please see her first. Thank you very much. Well, what a day to be without gummy bears.
Yours is right back hand, just start walking. The poultry, and then the pictures of the office. Okay, and your right thumb front. Place it flat right there. Move on.
They always have smiling faces on. Do you notice something?
You gotta do it way darker.
Put you in a good mood, just looking at them.
Place it right there.
before you eat them.
Before you behead them.
Do it one more time. Let me get 2 copies of it.
I know.
Place it right there. Okay, I'm gonna change my judge.
Okay, this is it. Thank you. 25 CR 1398 is called the State of Texas versus Robbie Lee Guillory. That is you, sir. You have to speak out so she can hear you. Okay. And you are here with your attorney, Mr. Turk. And does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
We may judge.
In summary, I'll need a pad sooner or later. In summary, there you are. In summary, this indictment alleges in paragraph 1. Oh boy. In paragraph 1, that on or about September 8th, 2025, in Jefferson County, Texas, you committed the 3rd-degree felony of indecency with a child by exposure. Do you understand what you are charged with here, sir?
Yes, sir. Yes, sir.
Yes. Are we going on both?
We only need one judge.
One judge.
Okay, because this is a second, it's shown as a 2nd-degree felony. We're just going to put that as 3rd degree, correct?
No,
No, sir.
it'll be a second.
I need one of the priors because it's the
Okay.
time that's agreed upon is within the 2nd-degree category. And I will inform the court. The reason for that is the state could have given notice as him as being a habitual offender.
What's the other crime that that's not listed that would have made him habitual? I've got 2
That's a
deliveries. of
related
controlled
question, Judge. So
I mean,
I'm showing 2 deliveries of controlled substance convictions
Same.
in 2002 out of the 252nd District Court of Jefferson County.
all right, so the other matter is actually an indecency with a child where he was convicted back on February 8th of 2018 and received a 5-year sentence. I do not know why it wasn't included in our indictment. I took it into consideration in making the agreement that we did and Mr. Guillory has agreed upon.
Okay, so on this though, you want to go on paragraphs 1 and 2 of the indictment? Is that good?
Yes, sir.
yes, Judge.
All right. So, once again, allegation 1, paragraph 1 states on or about September 8th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of indecency with a child. In paragraph 2, this alleges that on April 22nd, 2002, in the 252nd District Court of Jefferson County next door, you were convicted of the felony of delivery of a controlled substance. If both of these are proven true beyond a reasonable doubt, you are facing a 3rd-degree felony, which is subject to punishment as though it were a 2nd-degree felony because of the enhanced prior conviction. And that's the way criminal law works. You are punished for the circumstances of the crime. That's part 1 of a sentence. And part 2 in the equation is criminal history that may be involved. And so you have a criminal history and the subject matter here means if those were proven true, then you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand what you are looking at, sir? Okay. An agreement has been reached in your case that you would be pleading guilty, sentenced to 15 years in prison. And this says the parties are proceeding on paragraphs 1, 2, and 3. Is that right? We only need 1 and
2 and 3 are on the same offense date, so you don't need them both, Judge.
So do you want me to just take
Yes,
out?
sir. Take out 3. He pled on count 2.
And you would be sentenced to 15 years in prison. Is that your understanding of the agreement, sir? Yes. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to the allegation in paragraph 1, indecency with a child by exposure? And this alleges in summary that, again, on or about September 8th, 2025 in Jefferson County, Texas, with the intent to arouse or gratify the sexual desire of any person, you exposed your genitals to a child younger than 17 years of age, knowing that that child was present. Are you guilty of that? Are you pleading guilty voluntarily and because you are guilty of what it alleges? And then paragraph 2, which alleges that on April 22nd, 2002, in cause number 82478 in the 252nd Judicial District Court of Jefferson County, Texas, next door, that you were convicted on that date of delivery of a controlled substance of first-degree felony. Is that allegation true and correct as it is alleged, sir? Are you pleading true and correct to that voluntarily and because it is true?
Yes.
I'll show you here what is marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection, it's admitted. Among other things, Mr. Guillory, this states that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that true? State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, Judge.
Is there anything to add? I'm going to follow this agreement. If nothing further, Mr. Guillory, I will find that on paragraph 1 of this indictment alleging the third-degree felony of indecency with a child, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And there's sufficient evidence under State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of that allegation, that third-degree felony of indecency with a child by exposure. And then paragraph 2 goes on to allege, and you have pleaded true to its allegation that you committed the first-degree felony and were convicted of that, of delivery of a controlled substance in 2002 in the 252nd Judicial District Court of Jefferson County, Texas. I find you have pleaded true voluntarily, knowingly, intelligently to that allegation, and it is found true beyond a reasonable doubt. Thus, this is a third-degree felony, but it is enhanced in punishment to second-degree felony punishment, which carries with it no less than 2 nor more than 20 years confinement in prison. I'm following this agreement of a sentence of 15 years confinement in prison. I find you guilty beyond a reasonable doubt of paragraph 1, the third-degree felony of indecency with a child by exposure, and paragraph 2, the prior conviction in 2002 of delivery of a controlled substance, a first-degree felony from the 252nd Judicial District Court of Jefferson County, Texas. This all constitutes you being found guilty of a third-degree felony, though it is enhanced in punishment to a second-degree felony, carrying with it up to 20 years confinement in prison. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years confinement for the allegations you have pleaded guilty and true to in this indictment. Do you understand what has happened today, sir? Anything else you need to ask? Okay. And again, you will be given credit for all time you have served in accordance with that case. Anything else? That is all. Paul Jones?
Judge, if I might hold that one, that was just given an offer that Mr. Jones might consider. We might be able to make.
Christopher Smith?
That's the one that got reset to the hospital.
I think that looks like he is
is?
the hospital.
Okay. Adrian Watson?
Judge, just got an offer on that one. There's considerable amount of video on that one I'm trying to get through, so if I can.
That's going to be reset for how long?
4 weeks.
You got it. You're going to get back with me though here on this other
I'm
one.
about to go talk, but just told me.
Paul Jones, John, Jock Harris,
On the other side, I'm waiting for them to bring him over so we can.
Ryan Leax.
He's ready to lead to the court.
Ryan Leax, please. Thank you. There's no agreement on this one?
No.
Oh, here's the other one.
I'm sorry?
He had two. I'm sorry. Nice to meet you.
There's no agreement on this? No. And probation office is here on this one. Thank you. Come on up, Mr. Leax. Are you Ryan Taylor Leax? Yes, you got, okay.
Yes,
So you were here with John West, your attorney, and the state's attorney is present, and the probation officer in your case is also present. You were on probation in 2 cases, correct?
Yes, sir.
All right. And what we have is, let me put them in numerical terms. First one is 24 CR 1178, and that, and then the second one in numerical sequence 24 CR 1180. Each of these are burglaries of buildings. Correct?
Yes, sir.
Okay. Does the defendant waive a formal reading of these motions? Can we proceed in summary?
We can, Your Honor, please.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Can we put these together since they're alleged
Yes,
to
please.
be, there's similarities in the dates and the types of subject matter that all of this occurred. All right. In summary, each of these cases involve motions to revoke probation that have been filed as of May 8th of last year, 2025. And in summary, each of them similarly alleged that on September 16th, 2024, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, probated for 10 years for each of the cases of burglary of a building in each charge. Is all of that true? Okay. Well, this states that you entered pleas of true back in June of 25 to allegations 1 and 5.
Yes.
So we're going to just make sure that, why did we postpone all that?
I don't know. I think it was one of those you continue him on probation to see how he was going to do. So my
I don't know if they are. Is that what we did? Why are we here? You didn't, you
Well,
failed?
Yeah, he failed to appear, with it December, no. what was that?
I don't have any updated motions or any of that information at all with me. I don't. Generally, we get, you know, for subsequent actions, we've already dealt with this. We need an amended motion, I think, alleging whatever additional violations have occurred. Isn't it? That would be normal.
Back in April of 2025.
That's,
Where,
it was?
yes, it happened in Harris County and they gave him critical time served.
There was another incident happened in Harris County, Your Honor, where he was charged with a felony. However, they did reduce it down to a misdemeanor and he got 45, 48, something like 40 something days. 48 days. 40, I know I looked it up earlier, 48 days credit time served.
Help me
But there, Judge, there has not been an amended NPRQ file since its failure to appear in November. We issued a warrant for his failure to appear for I think it was just a status hearing to check. But we did a motion in advance in June. He set up for a status hearing in November. He failed to appear and we issued a warrant for his arrest. But there has not been an updated NTRP filed since that time.
We need that.
And the failure to appear, Judge, just because I was confused, is to here and not to her meeting, is a failure to appear in court.
Yeah, well, whatever conditions of probation that have been allegedly violated, that needs to be included in a first amended motion, okay? And can we, can we get that?
So
done
Judge, the
as soon
only
as possible?
other addition is that he failed to appear to court.
Well, we still need that alleged in something so that we can have some tangible item to work off of, and we'll call it a first amended motion to revoke probation. Okay. We get that as soon as possible. We'll get him back. Let's review it in 2 weeks.
Week, 2 weeks, whenever you want.
2 weeks.
I'll be here.
All right.
I do have. Stop here, one right above that, the one I gotta do paper off.
What about Jadrian Manning?
He is in, he's not here, Your Honor, he's in the Middleton Institute, and they're gonna try to, according to Ellen, they're gonna get him back here to take care of that. He's still in contact. We just need to,
Okay, how much time we want to review it in 4 weeks?
whatever, I don't know what.
Let's review that one in 4 weeks, please. Jadrian.
Whatever the timing is.
Manning,
Your Honor.
Bob. And Robert Leon Weaver.
He wants to talk to you, that's how I'll talk to him.
I don't, that's not the way it works. Don't
Explain it to him.
Okay. Jock Harris.
I need to fill out the paper on that one. You know, he's back there and as soon as I need to. Get that.
Okay, what is it he wants to, Robert?
He is claiming that he should not be revoked off probation because he was never guilty of anything. And that he doesn't understand why. And he has told me,
Oh, boy.
he's fired me multiple times.
Okay.
About this.
Yeah, this is Edgar Pons.
Oh, he was found competent, I think, but he's not very rational and doesn't seem to. So,
Bring Robert Weaver in, please. Yes, sir.
Right.
Huh?
So we may need to reevaluate.
It just happened in last month.
Oh, then I will shoot a silence to you. If you can speak to me,
No, this is dated December 3rd.
Yes.
No, we can't be doing monthly evaluations.
I agree, Your Honor.
Who's doing?
Who's Mr. Laird's case?
Yes, sir.
Weaver.
Yes.
Come on up. You're Robert Weaver? You're Mr. Weaver? Yeah, I recognize you. Robert Weaver. Here in 24 CR 121, Mr. West is your attorney and the state's attorney here and the probation officer is here. There is a first amended motion to revoke probation that has been filed in your case, Mr. Weaver. And it states.
Of habeas corpus, if I may?
No, it's a motion to revoke probation. You certainly are, though, experiencing a habeas corpus right now because here you are. Your body is before the court, and that's what that essentially means. You are on probation for 10 years for arson as of May 6th of 2024. And there are 7 allegations of violations, which include committing the offenses of public intoxication, obstruction or retaliation. That's all in May of 2024. One of those is 3 days after you were released. You were placed on probation and released. Within 3 days, you were committing the offense of public intoxication, according to this. And then 8 days later, you were charged with the offense of obstruction and failed to report to the probation office as directed on May of 2024, which was the day you were placed on probation. You failed to never become intoxicated by being intoxicated. Then there are 2 additional allegations which allege that you committed the offense of assault causing bodily injury on May 2nd, 2025 in Harris County, Texas. And also on that date, you committed the offense of criminal mischief. So if one or more of these allegations of violations have been proven, then by a preponderance of the evidence or greater, your probation can be revoked and you can be sentenced up to 10 years in prison. Do you understand what you're facing here, Mr. Weaver?
I do.
Okay. Mr. West is your attorney here. What are we doing today, Mr. West?
Mr. West,
Huh?
I do need Mr. West.
He's here if you need him. If you want to represent yourself, is that what you want to do? You can do that.
Of course.
That's not a wise thing to do, but he has been appointed to help you if you need it. Do you understand? He's going to be right here and he's going to be ready, willing, and able. You want to represent yourself? That is your decision. But historically, people who represent themselves fail miserably if they are not familiar with the rules of evidence, the rules of procedure, the rules of the penal code, and have experience and training in this. But you're a grown-up, you're an adult. If you want to represent yourself, you may do that. Is that what you want to do?
Yes, sir.
Then are you making that decision?
If
Don't interrupt me because we both can't speak at the same time. Then she can't take it down, but you'll have a chance to be heard fully. Okay. And if you want to represent yourself, are you doing that after thinking long and hard about it? And you've had a chance to see, I guess, and talk with Mr. West, haven't you? Yes,
sir.
Okay. And after those discussions, is that what you want to do as an adult, clear-headed, thinking, a competent person? Do you want to represent yourself in this matter?
Yes, sir, Your Honor.
Okay, you will be allowed to do that. Mr. West, though, will be right there if you need to refer and get any help whatsoever. He's your lifeline. He's within 10 feet of you. Okay?
I understand.
All right. And do you waive a formal reading of this first amended motion to revoke probation? And can we proceed in a summary fashion?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm that any statements you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? If you make any statements, will they be the truth?
Yes, sir.
Okay, lower your hand. In summary, sir, this first amended motion to revoke probation alleges that on May 6th, 2024, in this court, you were sentenced by this court, me, to 10 years in prison, and that was suspended. I placed you on regular probation for 10 years for the second-degree felony of arson. Is all of that true?
May I defend myself?
Yeah. Well, is all of that true?
In my own defense, my attorney was preceding that trial. I spoke to him briefly in December the 18th, approximately, and I relieved him of his duty. You know,
Maybe this helps your recollection here. I'm going to show you some items that are called written plea admonishments dated March 25th of 2024. And is that Don Dusler?
Yes, sir.
The attorney? Here, look at those. Do you recognize that? Is that your signature?
don't have my reading glasses. I do not have my reading glasses.
You don't go without them? Here, borrow his. Borrow his. Thank you. Those are reading glasses.
These are not legally binding signatures, Your Honor, because
Do you recognize those as your signature?
User actually presented himself and he was dismissed.
Okay.
Is that your signature right there?
Okay, here's what we're going to do. I see where this is.
Right here, no, that-
I see where this is headed. We're going to have a hearing on
Yes,
this. Okay. And when are we picking a jury today? We're doing it in the morning? What are we doing this afternoon? Here. What do we have set for this afternoon? Settings? Can we do it this afternoon? I mean, it's set for today. Can we bring him back this afternoon? And can the state be ready to make its presentation? Because
I can do the administrative.
I'm going to
and do the new office.
I understand. I will just enter denials on each of these because I see where we're headed. The court will also note and put into the record that the defendant was evaluated on or about December 3rd of 2025 by Dr. Ed Rapond, licensed psychiatrist, as the court requested that Dr. Rapond evaluate the defendant for competency. The report was prepared and it was placed into the record at a hearing on January 5th of 2026. And the court found, based upon Dr. Rapond's evaluation, that the defendant is competent to proceed to a resolution of his legal issues. And he does have a mood disorder, which is currently being treated and he is stable while taking his medications properly. And
no, on my medication.
why not?
I lost it when I was on vacation from May 3rd of 2024 23-year review.
No, this states as of December 3rd, 2025. This states that you were on medication at this time and it was not, and you are not in need of involuntary psychiatric treatment or intervention. And is aware that your next court date is early January 2026, which we had to postpone. You were able to accurately identify your court-appointed attorney's name, and in your mental state, you were able to follow legal proceedings and would be able to conduct yourself appropriately in a court of law only if you choose to do so, this states. And you do possess sufficient ability to communicate with an attorney, and you have a reasonable degree of rational understanding of the preparation of defense. You have made your decision voluntarily and knowingly, and you are competent to decide whether to represent yourself or not. It's not a wise decision to do that, but you are like competent adults, you are allowed to make your own decision, whether it's a wise one or a poor one. So we will have a hearing this afternoon on this, and just be prepared. I ask the state to be ready to make its presentment. And Mr. West, I'm going to ask you if you'd be so kind to be present, and we're going to do it at 1:30. Yes, sir. Be present. And if he needs any help from you, then he can speak with you. Yes. All right. That is all. Thank you.
That's good. Thank you.
Here we go. All right.
Signed up for the right man. With the hairs, that's no way open that has.
I have Roger Carter.
Yeah, that's fine. Decent back. Well, sure.
You want me to go back there, or what do you want to do?
Well, I did have the medical.
What do you want to do today?
Well, I'm asking for a medical bond. I had the person in charge of the permit that has subpoenaed for today. I guess they want the subpoena. I don't see him. Never been in contact with him.
Is anybody here?
Not from in response to the subpoena. I wanted his medical condition is the issue. He may be able to testify regarding it. What's a jail?
Does the state have anybody
medical staff
on this? One, this is Mr. Laird. Do you have anybody from the jail here on this motion on a medical bond?
I do not.
You don't have anybody. We don't have it.
I have a subpoena. They should be returning the file on subpoena.
I don't know if there is or not, but that's y'all. I don't know.
What is this? I don't even. Some medical bond. I'm trying to get him out.
On who?
Roger Carter.
Roger Carter. Is anybody from the jail facility here? No? No answer. Roger Carter, I think he may be in a chair.
Like, he just serve me with anything? Is y'all serving me with anything?
Well, yeah, good to it. Like when I
Uh-huh.
clicks the bottom, all good.
I'm sorry about that. For us to get it or me to get it?
Well, you personally,
Is anybody, but y'all don't know of anybody here. So, well, what are we going to do if we don't have anybody here?
He could testify about his condition, I suppose. I'll just reset it and I'll see why they're not here. But they're under subpoena. I filed the subpoena, actually talked to them and confirmed.
Or do we need to do anything right now? If you don't have the people, if you're not prepared, and the state doesn't have anybody here as well, do we need to do anything right now?
The court could.
What do you want to
He
do?
could testify about what
Is that what you want to do?
Let's just do that.
25 CR 886 is called the State of Texas versus Roger Malloy Carter Sr. Is that you, sir? You were here. Right, Kimber, your attorney is present. And you've called this motion. Who you want to call?
I would call Mr. Carter.
Raise your right hand. Do you solemnly swear or affirm any statement you make will be the truth, the whole truth, and to nothing but the truth, so help you God? Lower your hand. Go ahead.
Mr. Carter, where are you presently housed at the Jefferson County Correctional Facility?
Mary's on.
Is it the medical dorm?
No, it's like,
The psych dorm? Is it in the back in the infirmary?
no, the primary is in the front. They won't put me up in there. I've been trying to get up in there. Won't. And,
What is your present medical condition?
I have a bad neck. I got cancer in my left lung. I got pancreatitis and diverticulitis, problems with my intestinal tract. I need my both rotator cuffs repaired and my left hip.
You say cancer, are you being treated for that at the jail or not?
No.
How do you
treat me for anything? Like they just gives me my daily meds and that's it. And it's so much agony, pain is a shame. I told them about it. They won't do anything about it.
Who is your nurse? Who with the nursing staff, the individuals that you're doing?
It's like 5 or 6 of them. I don't know much of them name. One of them name is like Amy Kelly and Miss Charlie. I know there was, and the head nurse lady name is Kelly.
When was the last time you were transported to the hospital for treatment?
I think it was in November, no, October.
And why were you transported to the hospital for treatment?
It was I don't know, I think it was with my diverticulitis and my sugar dropped.
Diverticulitis? Are you being treated for that now?
Oh, and I'm supposed to have a maintenance medicine I take every day.
For that, who is your treating physician in the when you're not in jail?
It's can't think of his name right now, but it's through hospice.
Through hospice?
Yeah.
Yeah, I guess if I could reset the hearing to see why that subpoena wasn't honored by the jail staff, and if necessary, get a writ of attachment to have it here.
Anything?
No, sir, I'm looking at some jail incidents.
How long have you had this condition?
Since well, really, I've been broken up since high school.
I'm sorry?
I've been broken up. My back and stuff been since high school football. But my intestinal problem, I was born with it. My Lord, didn't born correct.
How long ago?
Since I was born.
Okay, these are long.
Yeah.
You understand, you have been indicted by the grand jury for murder of a human being on or about July 3rd of 2025. Well after you had these physical ailments, long after those physical ailments have attached. It's alleged that you caused the death by shooting him with a firearm and killing the man. Well, you can shake your head all day long. The grand jury indicted you for that, right? Didn't they? Okay, you understand that. Okay. So what they deemed is that in spite of your ailments, you were capable of causing murder and committed murder. That's what it is alleged. You understand that, which carries with it up to life imprisonment. You understand? Seriously. You have to speak out. So
Yes, sir.
Okay. How much time do y'all want how much time to gather more information? You said to reset this.
I'll be at trial the rest of the week. We can have 2 weeks. You know,
2 weeks good for everybody? All right, we'll reset this for 2 weeks. Thank you. Next, Sage Rodall. Sage Rodall. Oh, do we have a plea ready?
I'm working on one that actually got set, Judge.
John, did John have one?
You go ahead.
Is yours ready?
I've signed my paperwork.
I just need to sign it.
Okay, who is your man?
Mr. Harris, Jock Harris, sir.
Jock Harris. Thank you.
Sure.
Wherever that is.
It's going to be a half off of it. I believe we'll probably say, yes, court won't take this information. So
We need to see Mr. Harris first.
Can you do that with something or?
Here's.
No.
It's nice look at it, but.
Actually, you need road.
Mr. Harris over here. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Each of your right thumb print, right thumb. Place it flat right here on the wall. Okay, let's go one more time. There. Go for it there. Okay, okay. You stand in front of Judge, okay?
Sorry. Hey, man, here it is. That will give opportunity for review. I brought them inadvertently here. Those are set for sentencing later. I thought I'd review them. Okay, the case here is Jacques Harris. Is it Jacques or Jackie? Jacques. Okay. 25 CR 1498 is called. Mr. Harris is present with his attorney, Mr. West, and the state's attorney does. The defendant waive a formal reading of the indictment and arraignment. Can we proceed in summary?
Yes, Your Honor, please.
In summary, this indictment, sir, alleges that on or about December 6th, 2025.
October 6th, Judge.
October 6th, 2025. Sorry. In Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you are charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached in your case. You would be pleading guilty and sentenced. Is that a 6?
Yes.
Is that what it is? Okay.
You're pretty 6.
No, it wasn't.
Fun, Myra.
Whatever sentence shall not exceed a cap of 6 years in prison, which means you can be sentenced to no less than 2, no more than 6 years confinement in prison. You could be placed on deferred or unadjudicated probation for up to 10 years in length. You could also be sentenced to no less than 2, no more than 6 years confinement in prison, and that would be suspended and you would be placed on regular probation for up to 10 years. Is that your understanding?
Yes, sir.
Okay, you got 3 options there. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Oh, Pat's doing something funny. Here, I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney?
Yes, sir.
Are the contents all true and correct?
Sir.
Are the contents all true and correct
Oh,
here?
yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. States Exhibit 1, part of the record for all purposes. How do you plead again to this indictment as alleged, which states you committed the second-degree felony of burglary of habitation, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? All right, what I'm going to do is order a pre-sentence report.
Yes, sir.
And we will come back and everybody gets to sound in and add any additional information. And then we will put that on the record. And the court will, you can make your arguments and the court will make its decision. Okay. Thank you. How much time?
Judge, it'll be reset.